Please take your seats. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, CCJ Appeal number 7 of 2019, between Zulfikar Mustapha versus the Attorney General of Guyana, for the hearing of the appeal this morning. Can we have the appearances for the court, please? Thank you.
Please resume, my lords. Mr. Douglas Mendez leads me, Davish Maraj, Mr. Mohabir Anil Nandalal, Mr. Chandra Pratish Vikas Satram, Mr. Manoj Narayan, Ms. Marcia Nadir Sharma, and instructed by Ms. Candice Barrett.
Secretary Jones, the Attorney General appears in person and in association with Mr. Rathburn, QC, Mr. Hal Goddard, QC, the Solicitor General, Mr. Nigel Hoff.
Yes, good morning, Council. Mr. Mendez.
Good morning, Your Honors. Your Honors, yesterday the Court of Appeal apparently delivered their written judgments in this case. I've had an opportunity to read it, of course, but not an opportunity to analyze it, certainly not in writing in any event. It does not appear that much has changed, except that some doubt has now been put on the question whether the court had decided that the president was required to give reasons. It's not clear to me whether there is a clear position on that in the Court of Appeal. So I'll proceed on the basis that I will not be relying necessarily on the Court of Appeal judgment, because I'm not too sure exactly what their position is on that. But of course, we make the point that the president is required to give reasons. Now, Your Honors, if I may direct your attention immediately to the terms of Article 161 of the Constitution, and to point out that in the first instance that the predecessor to this clause, to this article, vested the power of appointment of the chairman of the Elections Commission entirely in the president. That is to say, he had the unilateral power to make that appointment. The power was controlled to the extent that he had to make the appointment among a certain category of persons, if we refer to that category of persons as persons who are either judges, former judges, or qualified to be judges. But the discretion was his alone. It was his appointment to make alone, as long as the person was eligible in the way suggested. What Article 61(2) obviously seeks to do is to render a change from a unilateral appointment by the president to one which is shared with the opposition parties in the National Assembly. And that is brought about in a particular way. But it is clear, would respectfully submit, that the intention is to, as best as possible, achieve the appointment of a chairman that is acceptable to both the president and the opposition parties in the National Assembly. That is the main goal of the article. Now, if I can ask you to look specifically at the terms of Article 161(2), hopefully it is coming up clearly. It starts from the bottom of that page, and it says, subject to the provisions of paragraph 4, the chairman of the Election Commission shall be a person who holds or who has held office as a judge of a court having a limited jurisdiction in civil and criminal matters in some part of the Commonwealth. That's at the top of the page. or a court having jurisdiction in appeals from any such court, or who is qualified to be appointed as any such judge, if we can refer to that category as the judges in the court below have as the judicial category. And then there's this additional category, or any other fit and proper person to be appointed by the president from a list of 6 persons, not unacceptable to the president, submitted by the leader of the opposition, after meaningful consultation with the non-governmental political parties represented in the assembly. Now, the first part of that article is obviously dealing with the question of eligibility. In order to be eligible to be appointed, you have to fall within the judicial category or otherwise be a fit and proper person. It is plain that the president would have the power to reject or not to appoint someone, or I should put it this way, that he would be prohibited by the article from appointing someone who does not fall within the judicial category or is not a fit and proper person. And of course, he will have to ensure that the person he ultimately appoints falls within those 2 categories. And likewise, the leader of the opposition, in submitting the list to the president, would have to ensure that his nominees fall within one category or the other. Now, that is the eligibility requirement in Article 61(2), and both the leader of the opposition and the president must ensure that the persons who they have under consideration are eligible. That means, of course, that if there is an appointment of someone who does not fall within either category, then that appointment is challengeable entirely on the basis that the person is not eligible. And the normal principles of administrative law would apply in those circumstances.
Now, the first category is quite clear, huh? Judicial category.
Yes.
But what about the other one? If I read any other fit and proper person, then I must understand that if you fall into the judicial category, then you're
Fit and proper.
fit and proper anyway.
Yes.
But okay, but is there anything we can determine what would be fit and proper?
Well, from the wording itself, because it describes the second category as any other fit and proper person, it first indicates that the previous category, those falling within the previous category are prima facie considered to be fit and proper. But because it says, or other fit and proper person, it is suggesting that the fit and proper person would have the qualities of a judge or somebody who is qualified to be a judge. So that category itself would gain some sort of inspiration from the further category, having regard to the wording itself, or any other fit and proper person. So I imagine that we would be looking for somebody who has an independence of mind, somebody who is impartial, somebody who is capable of proper analysis of the relevant provisions of the law that they would have to apply, but obviously not necessarily a lawyer, but certainly somebody of stature, somebody of integrity, and so on. Those are the persons that would ordinarily fit within that category of other fit and proper person.
And
so we learned that from it.
In particular, there is no requirement for any particular competence in relation to electoral matters.
No, there is no indication. Well, there is no indication that you need to know about an electoral system or have previous experience in running a similar department.
Because a judge might not have that.
A judge may not have that at all. A judge may go through his or her entire career and never do an election matter.
Yes.
That happens frequently. So that there is no specific requirement there that you have any particular expertise. So it seems that fit and, by the way that they juxtapose the judicial category with the any other fit and proper person category, the one is feeding off of the other. But the second category is included to basically to indicate you're not limited to lawyers, as it were.
Do we know why that category was introduced? Because the previous article didn't have that category.
It isn't clear from the historical record that we have put forward on the papers why that was added, but what it does indicate is that there was a previous, I believe, former Chief Justice, Chief Justice Bollers, I believe it was. Two former Chief Justices, I'm told, and it was disquiet in relation, I believe, to his tenure as the chairman of the Electoral Commission that led to moves to amend that particular clause, among others.
Oh.
That is what certainly the historical record that we have identified indicates. So I imagine it is because of the realization, well, judges may not necessarily be persons that the entire population have confidence in.
I'm
They
sorry?
expanded not necessarily, that they expanded it to include persons who are not lawyers.
So, Mr. Mendes, you would suggest that knowledge of the law would not be a requirement?
No, it is not, because they have deliberately included another category of persons falling outside of the judicial category.
And one more question on this. The ability of the leader of the opposition to submit a list is not restricted to selecting a list from this second category, any other fit and proper person.
No, it can be a combination.
Anybody who is eligible under the article.
Anybody who's eligible. It could be judges, fit and non-judges, all fit and proper persons, it doesn't matter. Okay. He's not limited in the names that he can put forward to the president. The only limitation on the list, of course, as long as they're eligible, is that the list must contain persons not unacceptable to the president. So that is the reading here. It says it must to be appointed from a list of 6 persons not unacceptable to the president, and I think that is the difficult part of the article requires.
So should there be some meaningful consultation between the leader of the opposition and the president in the first place to see the sorts of persons would be acceptable?
Precisely, because if the leader of the opposition is sitting in his office and he is consulting with the other opposition parties and so on, he is seeking to find persons, first of all, who are eligible, but he must bear in mind that the persons who he is putting forward are not unacceptable to the president. Now that obviously is a different concept from eligibility. The point is that a judge may be eligible by the mere fact of being a judge or a lawyer qualified to be a judge, but that person might be unacceptable to the president. So that's an entirely different consideration. Now the leader of the opposition would know obviously whether a person falls within the judicial category or not, and he would be able to discern from the analysis that we have just engaged in whether someone is fit and proper, but he will not necessarily know whether that person is not unacceptable to the president. What exactly that is not defined in Article 61.2. So it does require, if he is to know what the president may find not unacceptable, the premise is that there is going to be some sort of consultation taking place between the president and the leader of the opposition.
Particularly if all 6 persons have to be not unacceptable to the president.
Particularly if all 6 have to be not unacceptable. And of course, the idea of presenting a list not unacceptable to the president is, as we have submitted, in order to give the president real choice among a list of 6 persons. And in other words, that clause is deliberately put in there, it appears, in order not to give the leader of the opposition undisputed or unfettered power to put a list of 6 persons who are eligible, but nevertheless might have leanings towards the opposition parties. So that there is a requirement that the leader of the opposition approach the task in good faith to ensure that those persons are persons who the president might in fact accept and might in fact appoint. But he is not going to know that until he has some sort of exchange with the president and understands from the president who he might or might
Otherwise,
not
all he's
consider.
involved in is a guessing game. Is that what you're saying?
Otherwise, it's a guessing game. Otherwise, you simply will not know unless you are able to have a conversation with the president, unless the president is open and transparent about what he is thinking. It may very well be that as the Constitution is envisaging, that the holders of these two high offices will sit and discuss names.
Yes.
And the president will say to the leader of the opposition, what about this person? What do you think of that person? And they may, in an open discussion of that nature, actually come up with a name that they're both happy with. That's the ideal situation.
I want to make sure that we're both on the same page. Would you say that that is in fact required by Article 161(2)?
Implicitly, it is required.
Yes. Because,
Implicitly.
yeah, it's a list of 6 persons,
That's right.
not just a list in a sort of abstract way. Yeah.
You have to have 6 persons. The
And these
president has
persons
to have a
yeah.
choice.
That's right, yeah.
The president may choose to keep his cards to his chest by not saying, revealing exactly the person that he wants, for fear that the leader of the opposition might say, well, I don't like that person. So he might say, well, that person is acceptable to me, or he might give a list of persons that he might find acceptable, from which the leader of the opposition would choose, and they will. They may come to a list of 6 persons. The president, bearing in mind, of course, who it is that he might ultimately appoint.
So from what you have said then, and reading the information available to us, that, just as Hayden mentioned, meaningful consultation has not ever really taken place.
Did not take place at all.
There is meaningful consultation required, but that's with the non-governmental political parties
That's correct.
represented in the National Assembly. So
Yes, it is expressly provided there, so that the leader of the opposition is not going to do this on his own. If there are other parties among the opposition in the assembly, so he must engage in meaningful consultation with them, which means that he must not just simply say, "Well, I'm going to prepare a list. What do you think?" But he actually has to put names to them, so that the consultation can be meaningful, and that they then can agree upon the list of 6 persons. He is not, meaningful consultation will not take place if he just tells the other opposition parties, if they exist, well, these are the qualities I am looking for, put forward your names, and then he comes up with a list. Meaningful consultation in those circumstances, as the authorities make clear, is that you must actually, even though you may not have made up your mind as yet, you must at least indicate to the person who you're consulting with what the options are and what you are thinking, and get an informed, to be able to give the person an opportunity to provide an informed response.
Of course, we are reading that requirement into subsection 2 in
That's
relation, yeah. So it's not spelled out as expressly.
It's not spelled out expressly, but it seems that it must happen. There's no way that it can work other than as a consequence of consultation between the president and the leader of the opposition.
Yes, but at the same time, I am a little concerned about the degree to which we import, because there is a constitutional definition of meaningful consultation, is there not?
I believe that there is.
Yes, I think it's probably Article 232. And there are steps which are specified.
Yes,
And of course, the leader of the opposition must follow those steps
that's correct.
in relation to his consultations.
Yes.
But if you read meaningful consultation in a loose way into the relationship between the president and the leader of the opposition, you are not suggesting necessarily that those steps must be followed in the same way.
I'm not, if Article 161(2) intended that there be that meaningful consultation
Should have said
defined
so.
in the Constitution, it would said so.
Yes.
But it does not mean that there is to be no consultation at all. Logically, there has to be, because otherwise, as His Honor, Mr. Justice Hayton said, it would be a guessing game on the part of the leader of the opposition. If it is that there was not to be, or we don't read in some sort of some level of consultation in that process, then what would happen is the leader of the opposition put forward 6 names. The president says, well, not unacceptable. It may be one of them is not unacceptable. And he says, well, you haven't submitted the list, I'm going to the proviso. So it can't work that way. If the intention is that you have a chairman of the commission that both parties are happy with, then the process itself has to be meaningful, not necessarily using the definition of
Well,
meaningful
yes,
consultation.
and to avoid that sort of potential confusion,
Yes.
maybe we should not use meaningful
Word
consultation.
meaningful, but
Yes,
it certainly has to have meaning.
yes.
And for it to make any sense at all, for the purpose of Article 61(2) to be achieved. And of course, the article will obviously have to be interpreted in order to achieve its purpose. It have to be interpreted in a broad way, and not subject to any legalisms, as it were.
One would expect too that there would have to be good faith between
Both
the
sides
two
would have to be approaching it
officers.
with a genuine effort to arrive at a list of 6 persons that they're both happy with. Six persons who the president may be prepared to appoint.
Yeah, what if they had a consultation and the president, for example, indicated, well, I think this man would work.
Yes.
And the leader says, yes, I agree, but does
Yes.
not put him on the list.
Well, then if the other 6 persons are not unacceptable to the president, then the president must appoint from the list, even though the person is not, the person that they may have agreed upon does not end up on the list. But as long as the 6 that are on the list are not unacceptable to the president, then he is bound to appoint one of those persons. But it means, of course, he then has to make a determination in relation to each of the persons on the list, whether they are not unacceptable. And that would be subject to the normal public law duties that would be imposed upon any decision maker.
I went there because you said at one stage the president might want to keep a name close to his chest.
When I'm saying not to indicate that that is the person who he really wants to appoint, because if he says that is really the person I want to appoint, then the leader of the opposition might say, well, I'm going to put somebody else. I'm not going to give you what you want. So I'm just saying that in the course of the discussions, the experienced negotiators will know exactly how to put their case forward in order to achieve what they ultimately
Sounds like
want.
a game of poker, Mr. Mendes.
You can't get away from that because you're dealing with practical persons, you're dealing with politicians. So you can't get away from some element of that. But putting that to one side, they are nevertheless given certain constitutional duties which they have to perform in accordance with normal public law requirements. Good faith, taking into account relevant considerations, not acting for an improper purpose, etc. All of those things would bear upon them on the leader of the opposition in putting forward his list, but also on the president in making his determination as to whether they are not unacceptable. If the leader of the opposition insists upon putting persons on the list who are plainly unacceptable because they are party stalwarts, for example, then the president would be quite justified in saying, well, you haven't provided a list that is not unacceptable to me. You are abusing the process by trying to force me to appoint somebody that is going to be favorable to you. Therefore, I'm going to the proviso.
And he
But the
could do
third
so.
party will only know that if the president gives those reasons.
That's precisely. So part of there's hopefully, having consulted, they will come up with a list of 6 names, and that's the end of it. If, on the other hand, they are still jockeying, as it were, for advantage, and a list is put forward, the president would say, well, this list is not unacceptable, but in order for the leader of the opposition and the public to know, well, why is this list being rejected? Yes, the president would then be required to say why. And
Yes, so
tell
we
the
clearly
leader-
got away from unilateralism. So if in fact 6 former judges' names were put up by the leader of the opposition,
Yes,
and the president then said that's unacceptable, so I'm going ahead to appoint my own person,
yes,
giving no reasons,
Yes.
that could not possibly be the legal position.
it cannot. It simply cannot, because on the face of it, the persons are eligible and fit and proper by definition under this section. So if they are unacceptable, then it calls out for an explanation. Why, when the Constitution says that a former judge is a person who is eligible to be appointed, and indeed that was the position under the previous incarnation of the provision, that you can only appoint someone who is a judge, why if only judges or persons qualified to be judges are put forward, have you rejected all of them or some of them?
Okay.
We don't know
so,
which.
So the president gives a reason
Yes.
as to why he has rejected all 6 judges. What then?
Then we envisage, contrary to what has been suggested in the courts below, that you have a second round as it were. In other words,
Second round.
in other words, they seem to be suggesting that the leader of the opposition has only one opportunity, only one list can be put forward. There is nothing in 161(2) that says that he only has the opportunity to put forward one list. As a matter of fact, there would, if for example, the leader of the opposition puts forward a list of, as he did in this instance, by the way, of 5 persons falling in the judicial category and one obviously eminent person, a former military officer of great distinction, and the president rejects them as being not or unacceptable. If he rejects them on that basis, then it may be that only one of them he finds unacceptable, in which case it will make sense that he should say, leader of the opposition, I have no problem with these 5 persons, but this person I have a problem with because A, B, and C. So that the leader of the opposition now has the opportunity to supplement the list with somebody who, given the guidance that the president has given, would be not unacceptable to him. And it could encourage further discussion as well.
That's reading a lot into the article, Mr. Mendes.
Well, it does say, well, I'm following on from the logic of the position that it cannot be a guessing game on the part of the leader of the opposition.
Yes.
But I suppose this is why the optimum solution is for them to agree on 6 names.
That is the optimum solution. It may not work, but it's the optimum solution. This is why what makes sense is for them to sit down beforehand and discuss it, put forward names, come up with 6 names that they're acceptable to both of them, and take it from there.
But Mr.
But
Mendes,
sorry,
you go ahead.
I'm sorry.
No,
I'm just
just
going to say,
yes.
failing that agreement on the first round,
No, but
then if the president finds that some of the 6 are acceptable, or I should not accept, but not unacceptable, then in order to further the purposes of the article, there wouldn't be an obligation on him, we would respectfully submit, to indicate why. I mean, the purpose of indicating why, first of all, I would respectfully submit, is in order to further the purposes of the article, to get a list of 6 persons who are not unacceptable to the president.
Because acceptability is subjective, although it must be conditioned by objective grounds.
That's right.
So that the other side would have to know what are the objective grounds.
Precisely. You have to know why have you rejected this particular person, and be given another opportunity to put forward a list with 6 persons. So you would include the 4 or 5 persons, as the case may be, that the president finds not unacceptable, and then you supplement them. But of course, after further consultation and discussion.
You know, Mr. Mendes, so you say that reading into Article 161(2) is a second and a third list until you get it right? Does it come to an end at some stage?
No.
Well, when is the proviso triggered?
exactly.
I would put it this way, that Articles 161(2) does not preclude a second or a third round. But at the end of the day, whether there ought to have been a second or a third round would depend upon what actually happened. In other words, you look at the process that was followed and determine whether the actual process that was followed was in accordance with 161(2). That is to say, the process followed actually furthered the purposes. So I wouldn't say that Article 61(2) requires 2 rounds or 3 rounds, as the case may be. I'd simply say that it does not preclude, as the judges below seem to think, that you only have one opportunity and that's it. I would respectfully submit that if the facts indicate that the president had no problem with 5 and no problem with only 1, then a fair process or the constitutional underpinnings of 161.2 would require in those circumstances that there be a second round.
Could I ask, why would identifying the person with whom the president might have, quote unquote, a problem, not be a part of the consultation process before the list is submitted?
It should be.
Well, yeah, because it seems to me that plain reading of 161.2 suggests that there should be one list. I don't see any provision here for a second or third round. And the proviso is worded, if a leader of the opposition fails to submit a list as provided for.
Yes,
So he's submitting a list, and it is not as provided for, and that triggers the proviso.
It does, but all it is saying is that the appointment must take place from a list provided by the leader of the opposition.
Precisely.
That's what it says.
Yes.
But it doesn't say that he only has one opportunity to provide that list.
Well,
At the end of the day,
a list means one.
well, no, it is saying there that the appointment that must take place must be from a list. But it is not saying that the leader of the opposition has only one opportunity to construct a list which is not unacceptable to the president.
May I suggest that this could be handled very practically, because it could start with a letter, not a list, saying, well, I have in mind to put these 6 persons on a list.
Yes?
What do you think?
Yes.
And then you get a conversation,
Yes.
and then eventually you have a list with 6. I mean, these are words, but we need to be practical too.
And the letter, instead of 6, my brother suggests, the letter could be containing 9 names, or 10 names, or 12 names.
Never.
It could.
Yeah.
Yeah.
But then when the list in accordance with 161.2 is submitted, then I would have thought that is the list contemplated by the article.
Well, it is, Your Honors, it seems, first of all, that the provision requires prior consultation before
Yes.
any list is submitted.
Yes.
And with good faith on both sides, they ought to be able to find a list of 6 persons acceptable to both of them. That ought to be possible. That, of course, didn't happen in this case, as
Yes.
we are respectfully submitting. So maybe this is not the case to go on to consider, well, is there a requirement to have a second and a third round? Because, in fact, that is what happened in this case. So it's not necessary to determine, was the president required to go on to a second and third list, as the case may be. So I'm essentially having a conversation about something that is, to a certain extent, academic, because in this case, there were 3 tries, as it were. What we are saying, of course, is that even though there were 3 tries, there was not the level of consultation that Article 161.2 envisaged, so that there was a realistic chance that both parties, or that the leader of the opposition, would be able to put forward a list not unacceptable to the president.
Wasn't there between the second and the third list consultation between the parties?
It took place in the form of a provision of a list of qualities, which I would come to in a moment to indicate that really was not helpful at all. Or to the extent that it was helpful, it seems to have been abandoned entirely by the president, because my respectful submission is that the leader of the opposition did his best to comply with those qualities, only to find the president saying, well, you didn't meet those qualities at all. But I'll come to that in a moment.
Okay.
But I would respectfully submit that simply saying this is a list of the qualities would not be what is required. It requires
Names.
talking about names.
Exactly. So since that was never done, the question then is, was the procedure contemplated by 161.2 ever engaged in?
And that our respectful submission that is that it was not. Mm-hmm. And that is at the end of the day the
And what follows from that?
That the appointment must be set aside.
And the procedure must be properly engaged.
And the procedure must be properly engaged in accordance with the directions that the guidance that the court would give.
Yes.
Was this the first time that a chairman was appointed under the new Article 161? I mean, if it happened before, how did it go? How did that go? How was this handled?
This is the first time that they went to the proviso.
4 times chairman were appointed.
4 different chairmen have been appointed prior to this one.
Any problem?
Consensually. Yes, this is the first
So
occasion.
how did the procedure go in those cases?
I don't know, because I don't know. I would ask Mr. Nandlal to assist on that if necessary. But the point is that the parties never had to go to a second and a third list. They were able to agree a person, and that person was put forward. This is you now have 18 names being put forward by the leader of the opposition, all of which, as far as we know, are not unacceptable. Are unacceptable to the president, as far as we know, and we don't know why.
Yeah, we haven't examined what the president referred to as the subjective discretion, which is conditioned by objective factors, which I suspect you will come to, because that's the heart of the matter. But could I ask before that, is there a time frame implied in this process? Because the proviso says that if the leader fails to submit, then the president can act.
Yes.
So there must be implicit in that some window of time within which the leader must make the submission.
Absolutely, and of course the Interpretation Act would come into play to say whenever there isn't any time stipulated, it must be within a reasonable time.
Yes.
So that it can't be that the president asks or initiates the process of consultation, as he's required to do, we respectfully submit, and the leader of the opposition simply does not respond.
Mm-hmm.
If the leader of the opposition does not respond, then after proddings, the president would be entitled to say, well, you haven't given me a list, and therefore I'm going to the proviso.
But if they can't agree on a list,
Yes.
and that process of disagreement takes a long time, 8 months, for
The
example.
president would be entitled at some point in time to say, too much time is passing by, I would require a list by such and such a date. I have consulted with you, you know my views, etc. Please present a list.
Okay, and 8 months is a reasonable time.
Certainly is, yes. I would think. If the work of the commission obviously has to go on,
Yeah.
so that the
Of course,
parties...
it also depends, and not being mischievous, but it probably also depends
When?
on general when.
When this is occurring. If,
Yes,
of course, an
first
election...
elections or,
If it is just after elections, well, you might have more
longer
time.
time, yeah.
If it is closer to the election, obviously, there's urgency to it, and the parties will have to hasten slowly.
Yes.
I know you were talking about not unacceptable. Are you going to come back to that?
Yes.
Because you mentioned, obviously, if you're associated or linked with
Yes.
a party, that would make you unacceptable. But
Yes.
are there other categories, you think, of unacceptable?
Well, somebody who is ill, and the president may know that person is ill, and therefore may not be able to perform the functions because of illness, of whatever nature, physical or mental, as the case may be. The leader of the opposition may not know that, and the president would be entitled to say that person is not acceptable at all.
Age?
It depends. I don't think there's any particular cutoff point. Age may have an impact upon health and mental agility, so that may be a factor that the president would take into account as well. Because the post is a full-time post.
Yes.
As chairman, so that the person would be required to attend to the job with some rigor. So those are the obvious examples of somebody who, objectively speaking, the president would be justified in saying is unacceptable.
The president also, in his correspondence with the leader, did indicate certain characteristics.
Yes.
That he was looking for.
Could I go through the sequence?
Yes, yes.
I was going to deal with the authorities dealing with the reasons, but I'll come back to that at a later stage. If I can ask you to look at the first letter which is dated the 22nd of November 2016. And you will see this starts the process, and the president simply says, I would like you, in accordance with the Constitution of the Republic, to submit a list of 6 persons not unacceptable to the president, among whom I shall appoint the chairman. So that's all he says. There is no engagement with the leader of the opposition. There's no attempt to consult. There's no attempt to suggest a list of names, etc. The president submits a list of names, and then
The leader.
sorry, the leader of the opposition submits a list of 6 names with their CVs eventually.
But,
And
sorry,
then-
just to stick a pin. The leader did not ask for the kind of consultation.
No,
that
he
you're
did
talking
not. No, he did not. And we the point that we have made is that the obligation was on both of them
Both, yeah.
to meet with each other.
Yeah.
So both of them in those circumstances did
Were at
not.
fault, you'd say.
That basically. And if we look at the letter of the 5th of January 2017, the president says, I have examined the resumes provided for the 6 persons for my consideration, making a selection. And then he says, I am guided by Article 61(2) of the Constitution of the Cooperative Republic in choosing a person who is qualified to fill the position of chairman. Now, it's interesting the word that he has used there, qualified. The use of the word suggests eligibility as opposed to unacceptability. And then he goes on, I have found that the resumes of the 6 persons do not seem to conform to the requirements of the aforementioned Article 161(2). Now, is it that they are not eligible? Because the requirements that there are more than one requirement. There is the eligibility requirement, and then there is the unacceptability requirement, the not unacceptability requirement. He's not clear as to which one he's referring to. And he attaches the copy, and then he says, the 6 nominees therefrom are unacceptable within the meaning of the Constitution. The 6 nominees therefore are unacceptable with the meaning of the Constitution. I urge that a new list be provided of not unacceptable persons. But it appears from the language that is used there that there may be a confusion between unacceptability and eligibility. Because in the the 2 previous paragraphs, he's referring to qualifications. And then he says that the persons are not unacceptable. So there isn't any engagement as yet, it would seem, on the question of persons who are not unacceptable. And if it is that the president is saying that the persons don't meet the requirements because they are not eligible, then he would certainly have to say why. Because I believe of the 6 persons there were at least one who fell into the judicial category. That there was a person who was qualified to be a judge, having had 7 years at the bar. So at this stage, there are no reasons at all. The leader of the opposition does not know why. The leader of the opposition then engages with the president. So the leader of the opposition at this stage takes the step of initiating consultation and asks the president, could you let me have the qualities of the persons we require? But that apparently is all that happened. The president then, by letter of the 14th of March, yes, says you are requested at our meeting of the I think it's the 1st of March, my opinion of the qualities that the candidate to be chairman of the Guyana Elections Commission should possess. I forward a statement of those qualities, and then you see the qualities on the next page. And it says, the candidate should be a person who is qualified to be a judge of the High Court under Article 129 of the Constitution and under Section 5 of the High Court Act. So if you can look at those 2 provisions very quickly, you see 129 says that a person shall not be qualified to be appointed to hold or to act in the office of a judge unless he is or has been a judge of a court having unlimited jurisdiction in civil and criminal matters in some part of the Commonwealth, or court having jurisdiction in appeals from such court, which is the exact wording of Article 161(2), or he is qualified for admission as an attorney at law in Guyana, has been so qualified for such period, as may be prescribed by Parliament. So he's qualified for admission as an attorney at law. And then the High Court Act says in section 5, the period for which a person is required to have been qualified for admission as an advocate under Article 129(1)(b) of the Constitution for purposes of qualification for appointment to hold or act in the office of a puisne judge shall be 7 years. So that he is effectively using the very same formula in 161. But in those 3 paragraphs, he is therefore describing eligibility. The person must be a judge of either a judge or a former judge of a court of unlimited jurisdiction, or qualified to be, or a fit and proper person. But then he says the categories of persons specified above are necessary because such persons should have the following characteristics. That person is deemed to have wide electoral knowledge, capable of handling electoral matters because he or she is qualified to exercise unlimited jurisdiction in civil matters.
That is not a part of the eligibility requirement.
No, it isn't. But he seems to be saying that the persons, it's not clear what he's talking about. Is this persons who are not unacceptable to me? Because if that is what he is saying, he's essentially saying that a judge is automatically acceptable. Because that judge, because he or she is qualified to exercise unlimited jurisdiction in civil matters, is deemed to have wide electoral knowledge, capable of handling electoral matters. So it seems to be saying, well, if you fall within these categories above, that is, you're eligible, then you have these qualities that he then lists. And then he goes on, B, that person, the same person that he's talking about, qualified to exercise unlimited jurisdiction, will discharge his or her functions without fear or favor, that is, he or she will not allow any person to influence them, etc., and then so on down the line. It seems, one interpretation of this, in other words, is that if you fall within these categories of persons, eligible persons, the judicial category of fit and proper, then automatically you possess these qualities. At least that is one interpretation. Mm-hmm. So what then happens? The leader of the opposition, by letter of May the 2nd, 2017, then submits the names of 6 persons, 2 former judges, 3 attorneys of law, 1 a former magistrate, all of whom have the necessary length of practice to be qualified to be judges. So they fall within the eligibility categories that he points out in his letter. And Mr. Gerald Govaya. And when you read Mr. Gerald Govaya's CV, he is an extremely qualified and experienced person. He was in the military and so on. Sorry?
Fit and proper, you're saying?
Fit and proper. Obviously fit and proper, or at least presumptively fit and proper. So if you are going to reject those 6 persons in light of the qualities that the president has adumbrated what he's looking for, then you have to say why. Why have you rejected those persons?
Just to get the point on the record, the leader of the opposition did not object to these characteristics.
No, he did not.
Yeah.
He had asked for them and he got them. Mm-hmm. And then he is purporting, obviously, to comply with them by having 5 persons falling within the judicial category, and 1 eminent person, Mr. Govaya, who is I think I have described him in the written submissions as, let me have a moment. At page 8 of our written submissions is at page 951 of the record. Captain Govaya is a former military officer who served as chief pilot of the Air Corps of Guyana Defense Force. He's a fellow of the Center for Hemispheric Defense Studies at the National Defense University in Washington. He's a past chairman of the Private Sector Commission and has been integrally involved in national elections monitoring since 1997. So he even had election monitoring experience. He's the chief executive officer of a company which he founded. He serves as honorary consul of Barbados for Guyana. He's a recipient of the Golden Arrow of Achievement Award, or one of Guyana's highest national awards. So we say presumptively he is fit and proper. But the president doesn't say why he is unacceptable. And the other persons clearly fall within the eligibility categories. And reading his qualities, he is seeming to say that those persons listed above, if they are judges qualified to be judges, are presumptively persons who will know about electoral matters.
To what extent is the president bound by this letter?
But he is bound to the extent that he has said to the leader of the opposition, this is what I am looking for, and if you meet these criteria, they will be not unacceptable to me. So it creates a legitimate expectation that he is going to act upon it.
So what if he changes his mind?
If he changes his mind, he has to say why. And we have to be able to assess if he has acted properly in changing his mind, or whether he is abusing his power. But we will only know that if he tells us why. If he tells us why he has departed from nominees, he has rejected nominees who on the face of it meet his own criteria. Why has he rejected them? We don't know, because in his letter, sorry, I've lost my place. In his letter of the 2nd of June, he says, the Constitutional Republic of Guyana at Article 161(2) prescribes inter alia that this person should be appointed by the President from a list of 6 persons not unacceptable to the President. I have examined the curricula vitae of the 6 persons in light of the criteria defined in my letter to you dated so and so. I have found the list to be unacceptable within the meaning of the Constitution and of those criteria.
So initially, the Constitution gives the President this, what was called a subjective discretion.
Yes.
But you're saying he has objectified, or he has spelled out in the letter,
yes,
what he's looking for.
Yes, right.
And therefore, short of giving reasons for a departure from that letter,
yes,
he must abide by the criteria that he himself has set forth.
Absolutely. He can't in midstream decide he's going to change his mind. Can't encourage the leader of the opposition to go to the end of the branch and then cut it off and say, well, you did your best, and obviously the leader of the opposition did his best in constructing that list, presumptively, and then say, well, too bad, they're unacceptable to me, and I'm not telling you why. Just bring another list if you dare. Certainly it is a case where on the face of it, the President is not conducting himself in the way that Article 612 requires. That is to say, with a high degree of openness. He says these are the criteria. Again, as we have submitted, what is required is sitting down and discussing names. But they did not do that. What they resorted to was this method. The leader of the opposition asked for the qualities. The President provided the qualities. The leader of the opposition obviously complied. And if it is that there was actually something wrong with that list that we don't know about, then the President owed it to the court under the Huddleston principle, once judicial review proceedings had been filed, to say to the court, the reason why I rejected this list was because ABC. The reason why I decided that they did not meet the criteria that I set out and that I encouraged the leader of the opposition to meet was ABC. And in accordance with the authorities, this court is entitled to think that he didn't have any reason at all. That's why he didn't provide it. In other words, the decision is irrational. On the face of it, on the face of the evidence that has been provided to the court, persons meeting the eligibility criteria, persons meeting the qualities that are listed presumptively, But the president rejects them, and we simply don't know why. The people of Guyana cannot have confidence that the process envisaged by Article 161.2 was faithfully followed in the appointment of Justice Patterson, ultimately. And to a certain extent, he's a victim himself of the failure to follow proper process. More of the same takes place in that the leader of the opposition submits another list, and the president responds again, rejecting the list, and he doesn't really improve his reason giving, because he simply, instead of just simply saying that you haven't met the criteria that I set out in my letter, he then sets out the criteria in his response and says, you haven't met those criteria, without identifying which of those criteria. Is it that the 6 candidates didn't meet any of the criteria? None of those, that long list? Or is it one of those one aspect of the criteria that they didn't meet, and that is why he rejected it? We simply do not know. And at the end, so that at the end of the day, we have the appointment of a chairman, leader of the opposition having put forward 18 names of persons who are not obviously unacceptable. Not obviously. The president thinks so, but he hasn't told anybody why he thought so in relation to any of the 18 names. That cannot be, with respect, the consensual process that Article 161.2 envisages.
Now, suppose the president gives reasons, he didn't do it in this case, but suppose he gave them, and then the opposing side says, well, these reasons are really nonsense. So what are we getting ourselves into then?
If he gives reasons that
because well,
nonsense, then
well, yeah,
if, for example, he says, well, that person is, I don't know, they're from Berbice, and they're unacceptable as a result, then it's an irrational reason and is subject to challenge. In other words, his reasons then would permit...
They're reviewable.
That's correct.
So we would get into that. Now, suppose the president says, well, I have information about this person.
Yes.
And we all know this kind of information, let's say the intelligence service or anything like that.
Yes.
It's very hard to, of course, then the person himself could say, well, I've never heard of this.
Yes.
What kind of nonsense is this?
Yes.
Who is saying this?
Yeah.
So it's always difficult because this is, of course, not criminal law where you have to prove and all of that. So in this kind of area now, when you get in this area of intelligence,
yes, in which case the president would be able to say, even though I accept that I am under duty to give reasons, I cannot in this particular case, and these are the reasons, because I am relying on intelligence provided by, and presumably in any event, the president would have communicated that to the leader of the opposition. Mm-hmm. And again, both parties acting in good faith and responsibly. The leader of the opposition, I imagine, would insist at least upon some particulars, and on that basis, you would expect the leader of the opposition to desist. But if the leader of the opposition does not and says, I want to challenge it, then the president will come to court, as happens frequently, and says that there are national security reasons why this particular person was not acceptable, and I beg the leave of the court not to disclose those reasons.
Yeah.
And frequently the court accepts that. That is one of the exceptions to, first of all, having a hearing as well, and it is one of the acceptable justifications for not giving fulsome reasons, beyond simply saying that it falls within this category of reasons that I cannot disclose.
But proper consultation would avoid these situations.
It would have avoided it in any event.
We don't want to get there. Presidents should not be in court, they should govern.
That's correct.
That's exactly the point I was going to make, and there's a degree of disquiet that I feel with this court having to decide these kinds of issues, particularly, as you said in an exchange, that
Yes.
the reasons given by the president would then be reviewable.
Yes.
Now, it seems to me that, as my brother just said, to avoid all of this, and I think it's desirable to avoid all of this, that there should be, quote-unquote, meaningful consultation,
Yes.
so that the two political leaders in the country arrive at a decision that both can live with.
Yes.
And I think it's a tragedy, to be honest, that we're here in this way.
Yes.
I wouldn't have thought that anybody wants the court to be the ultimate decider, or put another way, to get too intrusive in the process. And hopefully with the kind of guidelines which might be given, the two leaders can in fact agree so that we don't have, this kind of task before us.
Your Honors, I'm mindful of the fact that I've used up the hour that has been allocated. I have made written submissions on the question whether there's an obligation to give reasons under the circumstances. I rely on those written submissions, unless the court wishes me to expand on any
there are some
aspect.
things I'd like you to make some submissions on. Without deciding, of course, but
Yes.
assuming that the court agreed with you that the appointment process was flawed, then what exactly flows from that?
Well, ordinarily, what would flow from that is the quashing of the appointment and sending the matter back to the president to make the decision again in accordance with the guidance that the court gives. What I would ask the court to do, if the court does come to that conclusion, is to hear the parties again on what further consequential orders ought to be made. I'm saying that because the decision that you make, or the orders that you make in this case, if you are minded to set aside the appointment, may be impacted by the result of the appeal which you are to hear tomorrow. In other words, if the court were to conclude in relation to that appeal that an election must be held, and that it must be held within a short period of time, then we would want to address the court on whether you ought to consider suspending, quashing the order, quashing the appointment of the chairman, in order that the election would not be disrupted. But we would only know exactly what the playing field looks like after the court has made a decision in that case. Because certainly we wouldn't want any order that you make in this case to disrupt an election that you order to be held, if in fact you think that should be done. Or put it differently, if the court in the appeal that is to be heard tomorrow decides that there is no election to be held, then there ought to be no restraint on the orders that you make in this case.
I'm having a problem. So if you are inviting us to find that the appointment of Justice Patterson was unconstitutional.
Correct.
And you're saying that notwithstanding a finding in those terms, what? That the appointment should continue and the appointee should still function in that position?
You suspend your order. That is why it would require further submissions, because a similar order was made by the Supreme Court of Canada in the Manitoba case. That is the one in which the court held that a slew of legislation was unconstitutional because it was not published in French as well as English. And the court had to grapple with the question, do we strike down that legislation, which is the consequence of saying that it is unconstitutional, and with the chaos that would result? Or do we suspend the order declaring the legislation to be unconstitutional in order to give the legislature an opportunity to pass legislation, including the French translations? And that is in fact what they did. So that there's a long examination of what the rule of law in those circumstances required, and they concluded that they were justified in suspending the order declaring the legislation unconstitutional.
Of course, the other way around would be to, and again, this is all hypothetical, would be to set very strict time frames and
As well.
timelines within which certain things should take place.
That is also an option. So that is why I'm saying until we know exactly what is going to happen, that we would ask the court to delay consideration of what other orders ought to be made.
Okay.
Much obliged to you.
I have
Sorry.
one question about your paragraph 64 in your written submissions. So I tried to follow that. You say the duties imposed on the President and the Leader of the Opposition to collaborate in finding a candidate acceptable to all sides are duties which are owed by both of them to the public. If therefore the Leader of the Opposition fails in his duty to engage with the President, to find common ground on acceptability, but stubbornly persists in putting forward lists which are unacceptable to the President, the public's right to a consensual choice will have been denied. If the Leader of the Opposition fails in this duty, the process would have been flawed and the appointment under the proviso in violation of Article 1612.
Yes.
It is wrong, in other words, to consider that an appointment is only challengeable if the President fails in his duty. But
Yes, that was specifically in response to remarks that Justice of Appeal Gregory made, because she was saying that there ought to have been engagement between the Leader of the Opposition and the President.
Yes,
she
I
accepted
understand
that.
Yeah.
But she was basically saying, well, it was the Leader of the Opposition's fault. He did not engage. And I'm saying from the point of view of a member of the public who has standing to challenge the appointment, the member of the public would be entitled to say, the process has been undermined because the Leader of the Opposition did not do what he was supposed to do.
Yeah.
Of
But I
course,
think the sanction to that,
Yes.
let's say the President does everything right,
Yes.
the Leader of the Opposition not, the sanction on that is that he just invokes the proviso, says, well,
yes, that may be so. I am,
because the President is the one who appoints,
yes.
he's the one in power, so to speak. But if the Leader of the Opposition would not do his part, well, then I thought that it is quite clear in that case, well, then the President has to invoke the proviso. Of course, if the President doesn't do his part, or both don't do their
Yes.
part, then we get in a different situation.
I would reserve that point, of course, for another occasion because it doesn't arise on this case. But I was just theoretically answering the way the Justice of Appeal Gregory had approached it,
okay.
by saying basically that it doesn't matter if the Leader of the Opposition did not do his duty as long as the President does. And I'm saying that the responsibility is on both.
Okay, thank you.
Yes,
Much
thank you,
obliged,
Mr. Mendes. We'll take a 10-minute break, and then we'll hear from Mr. Williams.
Please take your seats.
Yes, Mr. Williams.
May it please your honors, Mr. Rapthorn will begin.
Yes.
I'm obliged to your honors.
Yes.
Your honors, before I properly begin, with apology, I need to clarify an administrative matter, and that is to indicate to the court that it appears as if two separate written submissions have been done on behalf of the respondent. In fact, let me clarify that the written submission, which is dated April 25th, 2019, is the written submission properly upon which we rely.
Okay, what page is that at?
That is at page 970 of 998, Your Honor.
Yes.
25th of April, you say?
Yes, yes,
Thank
yes, Your Honor. And that the written submission, which is contained at page 923, is in fact a portion of the larger written submission. And in the event that the court needs some further explanation, that first document, that portion was sent to Guyana, and Guyana felt that that had been the full document. In fact, the full document is that document that is contained at page 970.
Yes.
So that they're not contradictory, Your Honors. I'm obliged to say.
But you still have to read both.
Indeed.
Together, that's the defense.
Well, the first one is contained in the second one.
Oh, okay, okay.
So that you only need to read the second one?
Yes, Your Honor. Your Honors, I begin and I will deal with the matter of the interpretation of Article 161.2 and any such article as allied to that one. My learned friend, Mr. Gollop, will deal mainly with the matter of discretion and the right to reasons, which featured quite prominently in my learned friend's address. Permit me, Your Honors, to begin at
Of course,
the point.
Mr. Thorne, you're dividing up your time.
Yes, and we will take.
Discussion.
Yes, yes, Your Honors. And I am depending on the court to limit me accordingly, and Mr. Gollop as well.
Yeah.
Permit me, Your Honors, to begin at a point and at a statement made by my learned friend in his address earlier, when he told the court, and this is where I begin. He says to the court, my learned friend says to the court, when asked if the question of acceptability is to be resolved before submission of the list, he answers and he says to the court, they, meaning the president and the leader of the opposition, ought to be able to find a list acceptable to both of them. I begin at that point, Your Honors, because that statement contradicts what the Constitution actually stipulates. It is clear that Article 161, Sub-Article 2, places the question of acceptability solely within the bosom of the President. If I may read it in part, it says, to be appointed by the President from a list of 6 persons not unacceptable to the President. And that is the literal reading of the Constitution.
But of course, the leader of the opposition would not put forward a list that is not acceptable to him.
Well,
I mean,
let us resolve that this way, and let us come to the position, and I hope we do, that there are 2 questions that arise in relation to qualifications. The question of eligibility, which is stated there, judicial office or the qualification for judicial office, which is objective. And the second qualification that arises is that of acceptability. And that, as I think I heard earlier, and I entirely agree with, is subjective. And it is solely within the mind.
No, what you heard is
President.
that it is subjective, but it must
Springs
be based,
from objective.
It must be based on objective
Indeed,
factors.
indeed. So that the person may, if the person has met eligibility in terms of qualification for judicial office or entitlement to judicial office, or he's a fit and proper person, the president may still find that person unacceptable.
Yes.
And that is where the subjectivity arises.
But he must find him unacceptable on some objective basis.
Indeed. Now, Mr. Gollop will deal with the question as to those reasons and what those reasons ought to explain.
I think we have to be careful in our language. You know, I'm not sure that the president needs to find the person unacceptable.
In order to disqualify him.
Yes.
Yes, yes. If he
Not-
wishes.
Not unacceptable.
It's unacceptable.
Well, I prefer to use the positive.
But the Constitution apparently has a different preference.
Well, it
Because
says
I-
not unacceptable.
Yes.
And it says that for good reason.
Yes.
And if I wouldn't go into that at this point. I'll come to it
No,
shortly.
I just wanted to make the point that there might be a distinction between the two things.
Might be a
Distinction between the two things.
between acceptability.
Between something that is not unacceptable
Yes.
and something which is unacceptable.
Indeed, indeed.
Yes.
And there's a reason the Constitution employs that language.
Yes.
We know it as litotes, which is to say that it is a technique in language where you employ the double negative to emphasize the particular power in the person.
Yes, my literary acumen benefited from your submissions.
Beg your pardon, sir?
It's fine, please.
Permit me to come.
Mr. Thorne, if non-unacceptability lies, as you say, solely within the bosom of the president, does the public and the leader of the opposition need to know what is it that really has given grounds for the non-unacceptability? Or that's just something that the president could keep within his bosom?
Can you say it's for me to know and you to guess?
And the court is really asking us to the requirement to disclose, either to the public or to the leader of the opposition. I can only make resort to Article 1612, which spells out the particular powers and the responsibilities of these two parties. And Article 1612 says what are those powers and responsibilities. It places the responsibility on the leader of the opposition to comply in terms of eligibility. It also places the responsibility on the leader of the opposition to consult with the National Assembly, with the opposition parties, all of them in the National Assembly. And then the question of acceptability arises. And it says that when he submits that list of 6 persons, the question of unacceptability or acceptability, I prefer to use it in its positive sense, the question of unacceptability falls to the president. And that is where I began, because my learned friend is urging this court to find that that question of acceptability is a joint exercise. We argue that it is not, and that if it were so, the Constitution would have said it. It says plainly, Your Honors, a list of 6 persons not unacceptable to the President. That is what it says, Your Honors. That is the clear reading of Article 161(2). And it says that that list is to be submitted by the leader of the opposition after meaningful consultation, his duty with the non-governmental political parties represented in the National Assembly. Now, again, we heard this morning that the process can be delayed by 8 months, perhaps, while the parties, permit me to say this, while the parties go on an expedition beyond the prescription of the Constitution, while, and permit me to say, Your Honors, that my friend is reading into this Constitution matters that do not appear on the face of the Constitution. That question of acceptability is left to be determined by dialogue prior to the official function of submission of a list. I'm not sure I agree with that. Indeed, I do not agree with that. This is an appointment to a very critical office within the administration of government in the Cooperative Republic of Guyana. It is a matter that is so important that it is dealt with in the Constitution. Remember, Your Honors, this is a constitutional appointment, and the powers and the responsibilities are strictly articulated in the Constitution.
But you'd agree, Mr. Thorne, that in order to make the appointment properly under the provision, there has to be consultation. Would you agree with that?
And I will answer this way, Your Honor. Consultation under the article speaks to consultation between the leader of the opposition and the National Assembly. That is what I read, and that is what is there, Your Honor. Now, if one wishes to make the point that there ought to have been some prior dialogue between the President and the leader of the opposition, that is quite a leap.
That is what?
Quite a leap, Your Honor. And if we begin to
You're saying there should be no dialogue between the leader and the President?
Shouldn't sensible, responsible adults have a dialogue on this?
I suppose there should be dialogue after he submits his list. And indeed, let us condescend to the facts. After he submitted his list, there was dialogue. The President responded, or the President's office responded to him.
So he's permitted, in your view, under the Constitution to submit multiple lists?
Indeed not.
I'm sorry?
Indeed not, Your Honor. The Constitution says a list, one list.
So he submits the one list.
He submits that
and
one
you're
list.
saying the only space there is for dialogue is after he has submitted that one list?
Except, Your Honor, that there is nothing in the Constitution that mandates the President to enter into dialogue with the leader of the opposition.
But you just said that dialogue was useful, did you not?
No, I'm saying prior to the submission of the list. We don't see that in the Constitution. Now, it would make sense, I would think, if the appointment is to be validated or given legitimacy, for the parties to have some dialogue after the submission of the list. And indeed, the events would indicate, the submission of 2 subsequent lists would indicate that there was in fact dialogue. And we do not condemn that. What we condemn, Your Honors, is the fact that they did have a second and a third list, which we submit was not necessary.
But to what end? What is the point of having a post-list dialogue if the leader of the opposition can submit only one list? What's the point of having dialogue afterwards?
He exercises his judgment, his good judgment, and he submits a list. Clearly, he is under responsibility to adhere to the constitutional requirement to submit a list of persons who are eligible.
You haven't answered my question. My question is, what is the point of having a dialogue after he has submitted the only list, in your view, that he's entitled to submit?
In the event that the President finds that his list is difficult to accept, I think the President can enter into dialogue with him. That the President may say to him, well, John Brown, we have intelligence information on John Brown. Mary Smith, we think that Mary Smith is far too political. I submit, Your Honor, that under the constitutional arrangement, that is reasonable, although it is not written.
Mr. Thorne, to what end? Because you add to that submission that only one list is permissible. So what would be the sense of the leader of the opposition having dialogue at that point when in fact you are saying that he can't submit any more names?
Perhaps we should not go as far as to say he cannot submit any other names, but the Constitution gives him the power to submit a list.
Well, you're confusing me now, because initially my thought was that once he had submitted a list, his job is done. And then you're saying that, okay, even after, it is only after he has submitted the list that there can or should be dialogue. Now, if you're saying that his job is done when he has submitted his list, what would be the purpose of that dialogue at that time?
Indeed, to give to the president the occasion to say to him that some persons on that list are unacceptable.
Well, in
And
this case,
I contemplate that that is the dialogue that transpires after the submission of the list.
in this case, he said 3 times they are all unacceptable, without giving any details.
Unhappily, that is what happened.
Yeah.
Now, let us look at the other position. If there is to be dialogue before the submission of the list, which is an ideal situation, the leader of the opposition submits a list of 6 persons, and if my learned friend is correct, he engages in dialogue with the president. And the purpose of that dialogue is to determine the fitness of those 6 persons. Remember, Your Honors, he submits that list.
When you say fitness, you mean their eligibility?
Eligibility. I beg your pardon, Your Honor.
Well, I would imagine a person is either eligible or they're ineligible. What you really need to have dialogue about is whether the president is going to find the person acceptable or not acceptable.
Yeah. Indeed. Now, dialogue on acceptability, I've submitted earlier, is solely within the judgment of the president.
Okay, so I think I get your submission. As far as you're concerned, 1, the leader of the opposition, his responsibility is to submit the names of persons who are eligible.
Indeed, my Lord, Your Honor.
And it is solely for the president to find whether these eligible persons are or are not acceptable. That there is no scope in the Constitution for the president to have any discussion with the leader of the opposition about his non-unacceptability or otherwise of persons either proposed or intended to be proposed. That's your submission.
Well, persons submitted.
Persons submitted.
And that it is probably too much of an expedition to ask the president to engage in dialogue prior to the submission of the list. And, Your Honors, that creates some potential difficulty. That in essence and in effect,
Sorry, you mean dialogue creates difficulty?
prior to the submission of a list,
Whether
Prior to-
whether prior or after, dialogue creates difficulty?
it could create difficulty. Remember, Your Honors, this is...
Well, how do you reconcile that approach, Mr. Thorne, with the actual wording of the section?
Yes, Your Honor.
Because you see here, as you read earlier, the eligible categories to be appointed by the president from a list of 6 persons not unacceptable to the president, submitted by the leader of the opposition. So the sequence seems to be that these things ought to be satisfied, and then the list submitted by the leader of the opposition encompasses those persons.
Yes. And I was about to say to the court that that depends on whether one reads it as a sequence of events or whether one reads it as a transaction without reference to any sequence. The question is, then, are we submitting to the court that the question of acceptability is to be determined prior to the submission of the list, or whether the question of acceptability arises subsequent to the submission of the list?
Yes. Well, the sequence contemplated by the article might suggest the former.
Well, I would submit that if we argue that it suggests the former, if we argue that the question of acceptability must be resolved prior to the submission of the list, it takes us on a potentially difficult course. Because this dialogue, and one knows not for how long it will transpire.
Reasonable time.
Perhaps 8 months. It means that the leader of the opposition, after consultation with the parties in the assembly, can in effect come up with a list of persons that the president cannot avoid. If you base it on discussions held prior to the submission of that list. In other words, that invites a situation in which the leader of the opposition may go safely away from the president's office and say, I have sent a list of 6 persons. He cannot avoid them. He must choose one.
I'm not sure how I follow that.
Well, let me repeat it.
In other words, instead of, following him after he leaves the president's office, why don't we accompany him into the president's office? So the two gentlemen in this case are together and they are discussing names.
Yes, Your Honor.
Okay. So the president says, look, this particular person, not acceptable. So obviously, good faith negotiations, he's ruled off.
Yes, sir.
But the president finds 6 persons suggested by the leader, perhaps by himself, to be not unacceptable. So these persons are not unacceptable.
Not unacceptable.
Okay. So the leader of the opposition presents that list, agreed with the president,
Yes, Your Honor.
as the candidates, and then he leaves the office.
Yes.
Would it be unreasonable in those circumstances to say that the president is obliged to choose one of those 6?
That is where it becomes an embattled area. That is where it becomes difficult, because it entitles the leader of the opposition to leave that transaction, feeling quite reasonably that one of his nominees not only will be appointed, but has to be appointed.
And what is wrong with that?
Exactly.
If those 6 persons are not unacceptable, that is what the Constitution says.
What is wrong with that constitutionally, Your Honors, is that in effect, the leader of the opposition can force an appointment.
No, he's not forcing an appointment. He's forcing an appointment among 6 persons who are not unacceptable.
president?
And that is what the Constitution says. I am getting the impression from you
Yes, sir.
that you are interpreting the Constitution to mean that the president can simply appoint whom he wishes.
Indeed.
That was what was in the previous Constitution. And there was a whole Herdmanston Accord and deliberations that said, we don't want that anymore. But you still seem to be stuck in what was there before.
With respect, Your Honor, I was hoping to depart from that and to indicate to the court that if there is previous dialogue, when the leader of the opposition leaves that transaction of previous dialogue and the submission of the names, it still falls within the president to reject the list then. To reject the list.
So
now, if the other side...
Just a minute. I want to get your submission properly. You're saying that even when the leader of the opposition submits a list of eligible persons, all 6 of whom are not unacceptable to the president,
Yes, Your Honor.
it is still permissible for the president to reject all of them. That's what you're saying?
The Constitution seems to be saying
No,
that.
it doesn't. Where does it seem to say that?
The Constitution is saying...
Well, we have your
that the
submission. I think you should move
yes.
on from that because...
Permit me, Your Honor. The Constitution, if now, the court will know that I have not accepted the position as to a sequence of events. I have not accepted the position that the question of acceptability must be determined prior to the submission of the list. My submission remains that the question of acceptability follows on the submission of the list. And that is the constitutional language. The Constitution says to be appointed by the president from a list of 6 persons, not unacceptable. That's the sequence.
And then it says submitted by the leader of the opposition.
Yes, submitted by him.
Once there is a list of 6 persons that are not unacceptable to the president, he has to appoint from that list.
He must select one of those 6 persons.
And if he finds at least one who is acceptable or non-unacceptable,
No, but if all
as the
6 are
language
acceptable,
says.
then at least one must be acceptable, don't you think?
The point is this, Your Honors. The point is this, that the Constitution does not force 2 transactions, and that's the point. The Constitution speaks as to a single transaction, and that single transaction involves the submission of a list and the treatment of that list by the president. Either he can reject all of them if he feels that no one on that list is acceptable.
Well,
In that interpretation, as I see it, then nothing has changed vis-à-vis the situation before, because in the old days, the president just appointed whom he liked to be chairman, and now, if I follow you, he could do the same thing, because you get a list of 6 persons, whether you discussed it or not, and you just say they are not acceptable, and now I take the proviso and appoint the man or woman that I want to appoint. So then there is no real difference with the situation before, and then that kind of interpretation is difficult if you want to give some meaning to the fact that there was a meaningful change made. You understand what I'm saying?
I understand.
So there is then no, in terms of power, there is no real difference with the situation as it was. Okay, you have to go through the motions to get a list from the leader of the opposition, but you're in a position to say, well, I subjectively reject all those persons, they are not acceptable, and now I'm going to appoint the person I want to appoint anyway. That cannot be the proper, I'm not saying what the proper interpretation is, but that, I have difficulty accepting that that could be the proper interpretation.
Indeed, the course of events would reveal that the president did engage on a course of consultation with the leader of the opposition, but he engaged on that course of consultation after the submission of the list.
And then he
which is why we had the 3 lists submitted.
And then he allowed the second and the third list.
Indeed.
Yes.
So that the important point of departure as between myself and the other side is as to this question as to whether dialogue takes place prior to the list or whether dialogue takes place after the list. My submission to this court is that there's nothing in the Constitution that mandates dialogue prior to the submission of the list. But I would think it is wholly reasonable that the president should engage in some kind of exchange after the submission of that list and exercise his mind on the question of acceptability, which is solely his constitutional responsibility. And the question of acceptability, Your Honors, is not within the constitutional domain of the leader of the opposition, because the Constitution says it quite clearly, not unacceptable to the president. That Constitution had the opportunity to say, not unacceptable to the president and the leader of the opposition. It doesn't say the leader of the opposition, so that the question of acceptability, based as it is, and it must be on objective qualifications or on objective circumstances, is solely exercised by the president. So
I think we have your submission there.
I'm
Mr.
obliged to
Song.
you. I'm obliged to you.
I would like to hear you on the reasons why you say that Article 161 is not enforceable by the courts.
Not enforceable, as the court believes. Your Honors, I would bring the court's attention to page 971, with page 970 of the 24th April written submission.
Yes.
And of course, we submit to the court that it is not, the question is not enforceable by the courts, and we say for reasons stated hereafter. We all know that there are some areas of official functions in which the courts will not interfere, either political sensitivity or the protection of persons' reputations and so on from public scrutiny. And there are several reasons, but I asked the court to condescend to the legal issues. And I don't know that the court wishes me to read what I've submitted at paragraphs 4, et sequitur, exhaustively.
So, okay, am I to understand that the thrust of the submission here is that once an appointment has been made by the president,
Yes.
the courts cannot inquire into the validity or the process or interrogate the appointment? Is that what you're suggesting?
The general rule is that unless there's illegality,
But how would the court know whether there is illegality?
well, if it is on the face of it, if there's some obvious infringement or infraction
What about if there is irrationality
or irregularity,
or irregularity?
yes.
So that is not quite unenforceable.
No, well, a court may inquire, and a court may inquire and find that it restrains itself. And I think that's the delicate point that sometimes needs to be made. Not that a court is prevented from hearing the matter, but having heard a matter, a court sometimes restrains itself. A court is quite entitled to say, well, this is one of these matters.
So, wait, if the court inquires, here's the matter, finds that there's evidence of illegality or irrationality
If it
or
finds evidence.
procedural impropriety,
Yes.
but it says, well, we're sorry, you haven't gone through this thing for 3 days and you submitted over the course of 6 months and so on, and we found all of these things. Nevertheless, sorry, we can't do anything about it.
Indeed not. The opposite is true, Your Honor. That if the court finds illegality, irrationality, procedural impropriety, a court will intervene. But where a court finds that those infractions are absent, there are occasions on which a court will restrain itself against making a decision. The court will decline to act. So it is not to say that the door is entirely closed on a court. What a court will do, a court restrains itself from intervening in certain constitutional matters and the matters of certain constitutional appointments. And one can think of, I mean, there are several examples. I don't know that a court has ever inquired into the appointment of a head of state. Well, certainly in the Westminster system, the appointment of a governor general, for example, one would expect that a court will treat that as sacred terrain and that a court will not engage itself on the matter of the appointment of a governor general. Here we are with the appointment of a very important functionary within the Constitution, the chairman of the Elections Commission. And we know the environment that we're in this Caribbean, Guyana. And that is a very, very important appointment. And I am loath to think that a court would easily interfere in the appointment of the chairman of an elections commission.
But the president is the head of a party, isn't he?
Yes, he is.
And therefore,
Republic.
he has an interest in,
Does have
in
an
this
interest to
matter.
serve, yes.
So, in a republic, not dealing with a kingdom, wouldn't there be some check and balance on the exercise of authority on the part of public officials?
There is always, and that check and balance is the court and the intervention of the court. And as I've said earlier, a court may itself find that it is slow to intervene if, for example, it considers that it is in the area, as we indicate at paragraph 12, at page 972, 998, that it is a constitutional convention. I don't want to take us back to the original point, but there are conventions into which a court will not inquire. Of course, there's the famous...
For example, if there had been a list of 6 persons not unacceptable to the president and he chooses one.
Precisely.
Well, if there's one of the other on the list who says, well, that is totally nonsense what the president said, well, of course, the court is not going to deal with that.
Yes.
That is something he decides after proper procedure, but I think this court needs to look at whether the procedure was proper and if it was in keeping with the Constitution, not just the literal text, but the whole spirit of the Constitution. Whether that is so or not, that is what we have to decide.
Indeed.
And if it is that the court decides that it is not in keeping with the constitutional procedure, then we will have to do something. But that does not mean that we want to interfere in who is exactly chosen by the president. If it is done after a proper procedure, that is his responsibility. I think everybody would agree with that. But there is the rule of law, and everybody, also the president, falls under the rule of law. You cannot escape that.
Yes. Indeed, in this matter, the court will find that on a perusal of the record, the other side had challenged the appointee on religious bases and whether his behavior at some funeral and that kind of thing. And a court properly declined to intervene on that basis, and the court felt safe within the confines of objective tests to be made as to the fitness of the person. So that even in this matter, there were areas in which the courts below declined to intervene, and that you could not bring evidence of the man's personality. Personality issues were not relevant. Personality issues were considered matters of sacred concern.
But that was an exercise of the power to intervene. That was an exercise of the judicial...
Indeed it was. Indeed it was.
...function, because as you well know, and as the president hinted, courts have been doing this for quite a while in the region. I mean, I seem to recall from the days I was in constitutional law, the case from Trinidad, Hochoy, I believe, in 1964.
Yes, Your Honor.
Where the Governor General was in fact amenable to the jurisdiction of the court. We have had courts inquire very recently in Jamaica into the appointment of senators. And in fact, the court found that, I think the leader of the opposition then, now the Prime Minister, had made some appointments, and the court, as I recall, rejected those appointments. So the notion that the court is not going to inquire into these things, I think, represents an era long gone. I think, of course, and I was trying to say this earlier, that the best practice would be for our political leaders to engage meaningfully and agree. But in the absence of that, if there's no agreement, then the court must step in, surely.
Yes, one doesn't ever wish to be heard to say that a court cannot intervene. I almost use the word trespass, that a court cannot intervene. A court certainly always must have the power to intervene where rights are at stake and rights are endangered. But having intervened, even a court will sometimes say, look, this is not an area for us. For example, in the enforcement of conventions, and Your Honors, in that regard...
So this is no longer a convention. It's written into the Constitution.
Well, they are. I suspect the President does not wish me to journey in this area, but if that submission as to requirement to dialogue prior may well be a convention, because it's not said in the Constitution. And Mr. President, I do beg to go back there, that quite often when we are interpreting constitutional provisions, literal constitutional provisions, we do incorporate or embrace conventions that arise. Now, if one says to us, and if this court says to us, ultimately, that there is a requirement for dialogue as between the president and the leader of the opposition prior to the submission of a list. That's a convention. It's not written there.
I don't think that is the way it was phrased. You know. I think it was suggested that that was implied.
Implied, yes.
Yes.
My learner friend said implicitly. He used the word implicitly.
Yes.
So that is implied into the transaction, into the relationship.
Into Article 161.
161.2.
Yes.
So that if we imply that obligation, that mutual obligation, we've created a convention. It's not written there.
We have created an implication.
An implication of a convention.
As you wish.
So that the question is, when these conventions arise, what will a court do? As in this case, will a court make inquiry into that? What I urge now is a convention. Will a court ask the president and will a court ask the leader of the opposition to disclose the content of any discussions that would have taken place prior to the submission of a list? It is a convention. Will the court trespass? Sorry, my lords, Your Honors. Will the court intervene in that area? I think not. I do think not. And Your Honors, that is why I urged in my written submissions that this question largely involves a convention and that courts are reluctant to intervene in the area where constitutional conventions arise, because as we all know, sometimes a constitutional convention is more binding than the letter of the law itself. And that is why we urge the court to find that this is a convention, this is an area of the nature of a convention, and we've drawn the court's attention to a text, Fundamentals of Caribbean Constitutional Law, and that is at paragraph 13 and at paragraph 14 of the written submission. And permit me to quote it, Your Honors. The authors state at page 75, and we quote, "Conventions are understandings, codes of constitutionally moral conduct, political practice born of long acceptance. They are non-legal rules of the Constitution that are respected and generally applied in practice, but are not enforceable in the courts. These informal rules control the exercise of legal political power. The Supreme Court of Canada explained that, and we quote again, "The main purpose of constitutional conventions is to ensure that the legal framework of the Constitution will be operated in accordance with the prevailing constitutional values or principles of the period." Now, unquote. Now, Your Honors, when we read that, are we not hearing echoes of that same transaction to which?
What is the convention? Is this a convention of non-dialogue between the president and leader of the opposition? But in which case, how come we had, is it 4 chairmen of the commission already appointed as a result of Article 1612 since 2000?
No,
I was hoping...
Your Honor, that would be inaccurate.
Yes, I was hoping that the court would not have taken that earlier statement uttered from the bar table for its entire truth. No evidence has been given as to undisturbed appointments earlier. That is something that was uttered at this bar table, and this court is, I don't think this court ought to take that.
So you're saying there's no evidence of a dialogue or non-dialogue? Therefore, we shouldn't be dealing with any conventions relating to that.
I would prefer, Mr. Attorney General, to address the court on this, because if the court takes it as evidence what had been said earlier this morning, I think the court may be misled into believing that 4 previous appointments were made without controversy.
No, just to say that since the legislation, there's been only one appointment. That person had only recently limited office.
Okay.
Since 2000.
This court heard this morning that there were 4 appointments, Your Honors.
So if there's only been one appointment, we can't have had any developed convention over the years, can we?
We have no evidence as to how that appointment went, Your Honors. No evidence whatsoever. But if, Mr. President, you allow me, sir, to return to the question of conventions, we urge the court to find that...
Mr. Thorne,
Yes, Your Honor.
the Constitution of Guyana was altered in order to create a new process
Indeed.
of choosing a chairman of the Guyana Electoral Commission. And that only happened 19 years ago. I wouldn't take into account whether there are 4 persons or 1 person. Let's put that to one side.
As the court pleases.
The point is, we are here interrogating the process that was set out in the amendment that was made in 2000. That cannot be a convention, Mr. Thorne.
As the court pleases. And therefore, Your Honors, let me close on this point in saying that the framers of this Constitution had the perfect opportunity to stipulate sequentially what ought to have been the process. They had that opportunity, Your Honors. And all that they have told the country of Guyana is that the leader of the opposition must consult with the National Assembly, submit a list, and that, permit me to urge this in closing, Your Honor, and that the question as to acceptability resides solely with the President, and that if the President finds that he is legally entitled to reject that list, the proviso immediately comes into being, and that he does not have to wait 8 months and engage in further dialogue on a matter as critical as this. Indeed, current events would indicate how critical is urgent appointment of a chairman of the Elections Commission, and that he uses the proviso. But as we've indicated, Your Honors, a draftsman can do these things quite easily in sequential order. What we have here, Your Honors, with respect, is not a sequential order. It is a description of a transaction which divides powers and responsibilities as between a leader of the opposition and the President. And that, I say this as well, I submit this as well, Your Honors, that the sum total of what we're hearing from the other side is that ultimately, and this is the central issue, that ultimately the leader of the opposition has greater control in the appointment of the chairman of the Elections Commission than does the President. Now, Your Honors, it is not a matter for a power struggle. It is not an occasion for a power struggle. But let us read the Constitution according to what it intends. And it is clear, Your Honors, that the Constitution intends that the leader of the opposition is intended to participate in the question of the appointment of a chairman. It gives to him the power, the responsibility, and the opportunity to submit 6 names. And one hopes that he will exercise that responsibility maturely and seriously, and that he will submit the names of 6 persons who are eligible. But the same Constitution says that as to the question of acceptability, that is the sole province of the President. And
Tell me
that
something. Is there anything on the record to suggest that any of the 18 persons that were submitted were ineligible?
It seems that way, and it is clear that the leader of the opposition himself conceded on that point. I like to be candid towards the court, and I cannot give that evidence. We can probably collaborate on that, but he himself collaborated in the withdrawal of 12 persons and submitted a third 6, so to speak.
Well, the President just mentioned acceptability. Huh? He didn't write about eligibility.
I thought the question was as to eligibility. Yes, I beg your pardon, sir. I think it was as to eligibility.
He used the word.
Yeah, no, what my brother is saying is that the President's objections seem to have been based not on the eligibility criterion, but the acceptability one, or the not unacceptability one.
At least that is the word he used. It's not quite clear what he if that really meant eligibility or something else, but he used the word unacceptable.
Yes.
Okay, so you went through the text of the Constitution, the sequence. Would you agree that both the President and the leader of the opposition have to act in good faith?
Indeed, indeed. They must act in good faith. They must act in good faith. And we know what we're dealing with here, Your Honors. And the framers of this Constitution would have been mindful of the fact, the political reality, that the submission of 6 or 12 or 18 names are tainted with political bias. There's always that possibility. But it gives to them the opportunity to act on the question, the objective question of eligibility. And a constitution can go no farther than that, Your Honors. A constitution will never, on this sensitive matter, arrive at the ideal. And that is what we hear the other side urging, an arrival at the destination of idealism. That will never be achieved. Will never be achieved. And so the Constitution does only as much as it can do according to the political realities in Guyana. Give each side an ample opportunity.
And then at the end of the day, the president picks his man.
And then at the end of the day, not picks his man, but the president considers the 6 names submitted by the leader of the opposition. And Your Honor, this is the Constitution. The Constitution says it, that if he finds that those names are not acceptable to him, that's it. As unfortunate as it may be, this court cannot create the ideal where the Constitution fails to create it. And that's the point. And in trying to create the ideal, and this is my learned friends on the other side, in trying to arrive at that ideal, what the other side is in effect doing, the other side is in effect saying that the leader of the opposition can and must always get their man. And that cannot.
But the other view is he never can, because he's playing a guessing game. He doesn't know what acceptability amounts. So he puts forward a list that's rejected, and that enables the president to trigger things off for the president always to get his own man or woman.
Well,
is that what was intended by the amendment in 2000?
That leaves us at a situation in which neither side may be able to get his man.
Well, you see, the impression I get...
Neither side may be able to get his man.
We're going wrong and wrong, Mr. Thorne. I think we need to hear from perhaps Mr. Dollop on the question of the reasons, because I wouldn't even make the intervention I wanted to make, because we're going round and round.
And indeed, that is on this one, and that is why the other side is forced to submit that both sides were wrong. That is the point at which, that is the ultimate point at which this case has arrived. In the words of the other side, that both sides were wrong, and therefore the court must resolve it by vitiating the process and sending them back at this stage. We submit, Your Honors, that that is not a proper recourse. We ask the court to find that the appointment was made in accordance with the prescription of the Constitution, and that it should be allowed to stand. Unless I can be of any further assistance to the court, those are our submissions on the issue as to the interpretation of Article 161(2).
Yes, thank you.
I'm obliged to you, sir.
Good afternoon, Your Honors.
Yes, good afternoon, Mr. Brother.
Exercises in public law always take us into discussions based on morality versus law. And what we're today engaged in is looking at what would be ideal, what would be an ideal situation in selecting a chairman of the Election Boundaries Commission of Guyana, as opposed to what the law provides. And in our submissions, we have looked at the doctrine of abuse of discretion. And our principle, the principle stated is a discretion, and the court spoke about this morning, a discretion is only reviewable if it is illegal, irrational, or is tainted with procedural impropriety. Once that has been certified to be non-existent, then the discretion of a public functionary cannot be fettered. So that what we are essentially examining is how did the president exercise his discretion in the appointment of the chairman? Did he act illegally? Did he act irrationally? Or did he not follow a procedure? I respectfully submit to the court that it must be found beyond any doubt that one of those categories was breached if the court is to say that the appointment of the chairman should be declared null and void, as my friend who presented the case for the appellant is suggesting. He has suggested, look, all of them were wrong, so the appointment should be vitiated. Now, I have dealt in the submissions on abuse of discretion, which we stand by, but I should like to draw specifically to the court's attention at page 986 of the record, paragraph 77 of our submissions. And I shall read those paragraphs. The foregoing discussion provides adequate support for the submission that the president, in making the appointment as he did, especially given the important considerations of public interest and delay, acted reasonably and legally in the performance of the duty vested in him under Article 161(2) of the Constitution. Indeed,
Mr. Gallup, but he would only have acted legally if he followed the requirements of the proviso.
absolutely, sir.
Okay.
Absolutely. I'm coming down, sir.
So the question is, well, did he follow the requirements of the proviso?
Just give me a chance to come down, sir. And I think the court
We do have, with respect, we do have your submissions, you know. We have the written submissions. So if you're...
he did follow the requirements of the proviso. He did follow the requirements of the proviso.
Well, the first requirement is that the leader of the opposition must have failed to submit a list as provided for. So, in what way did the leader of the opposition fail to submit a list as provided for?
The list must not only be submitted, but the requirement is that there must be a person there who is not unacceptable to the president.
Right.
And if one were to look at the submissions of my friend went through the submissions and he set out the factual background. And therein, he recorded from that letter of June, I think it is, where the president enumerated the qualities on request from the leader of the opposition. He set out the qualities which he was looking for. Now, I would respectfully submit that it rested within the discretion of the president. If he found among those persons one of those, one from within that set of criteria missing,
Yes.
then that would be a reasonable application of his discretion, because he found a quality which he was looking for absent.
Yes.
So that the discussion does not turn out anything to the contrary that would say that the persons submitted to the president were above reproach, that their conduct was not unimpeachable. I'm into the same double negative situation.
Yes.
Their conduct was not unimpeachable. The learned trial judge, in my view, and my submission to the court, who had the affidavit evidence and all the evidence that was produced in the hearing, was in a good position to examine the correspondence.
But we are in the same position as she was.
Pardon me, sir?
Aren't we in the same position as she was?
Yes, my lord.
I see.
Yes, my lord. That is why I'm saying that by urging the court not to interfere with what the learned trial judge found.
Now you're confusing me.
No, sir. Yes, my lord.
If we are in the same position as she was,
Yes, sir.
then it is futile for you to go on to say we must not interfere with
Well, very well,
her
sir.
view.
I-
We must now exercise our own
Yes.
judgment on the matter.
Yes, my lord, I understand the point you're making. I apologize, sir.
Everything seems to hinge on this question of what is not unacceptable. I'm getting the impression from you that the president was within his right to state that the lists that were submitted to him were of persons, either all of whom, or in each case, in the case of each list, at least one of whom was not
He
unacceptable.
found something wrong with all of them.
Good. How does the leader of the opposition, how does the public, how do we know which person he found to be not unacceptable, and on what basis he found that person or persons to be not unacceptable?
Well, that is the point I'm making, sir. Does the law require, in the exercise of a discretion, for the president to do that, to go that far?
Good.
That is the point I'm asking.
Your submission is that the president is not obliged to give any reason as to whom he considers, if he does consider anyone, to be not unacceptable.
Or what the reason was. I'm going to respectfully submit. And I'm coming down to that, sir, when I come to the second limb of my submission to the court, which I shall come to shortly, sir.
Yes, so before you do that, just to be clear, so the president sent a letter in which he indicated the characteristics of persons who would be not unacceptable to him.
Yes, sir.
Agreed? Okay. Was the president at that point then free to add other characteristics so that if the leader of the opposition complied with the letter and the 6 persons, hypothetical, met those characteristics, was the president nonetheless still free to reject all of them?
My lord, we are looking at what could be considered, respectfully, sir, the reasonable exercise of a discretion.
No,
And the
that's a very
reasonableness-
important question. I'd like you to answer that question.
Yes, I'm coming to that, sir. The reasonableness has to be looked at in the circumstances. What would happen if the president were confronted with a list after list after list after list by the leader of the opposition? Mark you, he had 3 now when he only required to have 1.
You wouldn't answer the question, Mr. Gollop. It's a very straightforward question. The president says, these are the criteria I want. I want a person who is A, B, C, D, and E. The leader of the opposition submits 6 names of persons whom the leader of the opposition considers to have fulfilled all of those 5 criteria. Is the president then able to say, you know what? There are 3 other criteria that I have in my mind. So even though these 6 persons meet all the 5 criteria I set out initially, they don't fill these other 3 criteria, and therefore I'm not accepting them. Is the president entitled
Yes,
to
sir.
this?
Yes, sir. Yes, sir. With respect, sir. But I'm also saying that the president was entitled to say, look, from among this list, there are persons here who fall short of the qualities which I have enumerated.
Did the president say that?
Now, that comes right down, sir, to the point whether he's entitled to give reasons. And my respectful submission is that you cannot fetter the discretion of a president to that extent to force him to give reasons for every single thing.
Okay, so the
And I'm coming
president is
down to
not,
that.
he's not entitled to give reasons. He's not entitled to abide by even the criteria that he gives the opposition, the leader of the opposition, that he wants to see fulfilled.
But nobody, sorry, sir.
And so if he's not so constrained by either of these things, what is different about this provision from the one that existed before?
Because you'll always be able to trigger the proviso.
Friend, my lords, unfortunately, Justice Anderson stopped me in the middle.
No, you answered him.
No, sir. I don't mean in answering the question. He asked the question before I had finished reading that section at paragraph 77, where I was trying to point out that he acted in accordance with the Constitution. Remember, sir, I started by saying that we're looking at what could be moral and what could be legal, what could be ideal, as opposed to what could be legal. And I was reading the point here at paragraph 77 of the submissions. And I was moving on to 78, where I say, as a final observation, it must be noted that Article 111(1) of the Constitution grants to the President, in the exercise of the functions under the Constitution or any other law, the unquestionable discretion to act in accordance with his own deliberate judgment, except in cases where by the Constitution or by any other law, he is required to act in accordance with the advice or on recommendation of any person or authority. That is what Article 111 says.
Yes.
And indeed, if we were to go to the Court of Appeals decision, if we go to the Court of Appeals decision, we will see exactly why that is supported and exactly why we're asking the court to find that the president carried out his task in accordance with the law.
Could we just, before we go there, look again at 1111?
Yes, sir.
Yes, the provision you just alluded to. It seems to me,
Thank you, Bilal.
yes, it seems to me that the phrase you're looking at is the president shall act in accordance with his own deliberate judgment. That's what you're focused on.
Except
Yes,
in those cases
yes,
where by the Constitution or any other law, he's required to act in accordance with the advice or on the recommendation of any person or authority.
yes. So where he's not so constrained in the last phrase of that provision, then he acts according to his own deliberate judgment.
Yes, sir.
In other words, I think that means that he doesn't have to consult anybody or act on the advice of anybody when he's carrying out that function. In other words, the two things are being contrasted with each other. In one instance, he has to act on the advice or on the recommendation of a person or authority. In the other instance, he doesn't have to act on the advice or the recommendation of a person or authority. He's deciding in his own deliberate judgment.
Respectfully, sir, I understand this provision to say he acts in his own deliberate judgment unless there is some other law, namely the Constitution, or any other law which requires him to act with advice or recommendation
Yes.
of any other person or authority.
Yes.
Now, so that he is not constrained unless he has, by law, to act on advice.
Yes.
The Court of Appeal,
But does that mean that he doesn't have to give reasons?
pardon me, sir?
Does that mean that he doesn't have to give reasons for what he is doing? That he acts on his own deliberate judgment?
I'm coming down to that, sir.
Okay, well, we
Respectfully, I'm
You,
coming right into
you
that,
have been
sir.
coming down for a little while.
I'm
now,
coming
Mr.
right
Patterson.
into that, my lords. Right into that, sir.
Keep us in suspension.
And sir, right following on to that reading is the little heading, the right to reasons.
Okay.
The right to reasons.
Good.
And I've read the submissions of the other side, and they have suggested to the court that the Court of Appeal said that no reasons were given. That is not exactly correct, because one justice of appeal said reasons were given. But I will come on to that, sir. And those of us who have been involved in the teaching of public law, my friend Counsel, I know we've met up on occasion to set exams for in public law. Only this week, as a matter of fact, while reviewing a paper on the right to reasons from a student passed on this case to me, so that it does not fall into the bundle of documents. I had it only on Monday. I could pass up a copy for the court, if the court so wishes. It is called, in the matter of an application for leave, in the matter of the decision of the Ministry of Education and the Primary Schools Principals Association, and so on, between Caribbean Book Distributors Limited. And there is a pithy little comment on the failure to give reasons. It is from Trinidad and Tobago. It is S764 of 1997 in the High Court of Justice, Republic of Trinidad and Tobago. And this is what the learned trial judge. There's a copy here, Bishop. Pardon me, sir. There is a pithy little comment on the right to reasons, failure to give reasons, and so on.
Whose judgment? Whose judgment?
Judgment, the judge is Mr. Justice Bisundath Ramlogan. Bisundath Ramlogan, before the Honorable Mr. Justice Bisundath Ramlogan. Would it be proper for me to pass up a copy?
Yes,
to
by
the
all
court?
means.
Pardon me, sir?
Yes, please.
Thank you.
There's another one here. You need some more.
As I said, I only got it on Monday, sir.
Yes. Okay, thank you.
Put it on
In the monitor.
Yeah, Could someone put it on the reader?
And down on the last paragraph of page 7,
Page 7, I think. Mr. Hardy.
thank you, my lord. These things happen when students turn them upon you out of the blue, as it were. Where it is desirable, while it is desirable that reason should be given in the interest of good administration and good management, if it were the general rule that
Sir, I'm afraid your assistant is not
I'm ahead of my
helping
assistant,
you
sir.
very much.
I apologize for the tardiness of my assistant. I
So
go
what
back, sir.
page is it we need to be looking at?
Pardon me, sir?
What page
Page
is it?
7, sir.
Page seven.
The bottom of page 7, the last paragraph, sir. While it is desirable that reason should be given in the interest of good administration and good management, if it were the general rule that the administration should give reason for everything that it does to all those who may be affected by its decision, administration would come to a standstill. The applicant must show that in the circumstances there was a duty to give reasons to him. That duty would arise if there were special circumstances. The applicant has shown none, and no authority has been produced to support the contention that confidential data should be given to him. Respectfully, the appellant has talked around the issue of reasons, but he has not indicated to the court at any level that there was a duty imposed by statute or the common law to reasons. Now,
Well, Mr. Gollop,
Yes, sir.
what about this Article 111(1) that we referred to before, where you say the President has to act in accordance with his own deliberate judgment? It doesn't say to act in accordance with his own whims, does it? Therefore, deliberate judgment must be capable of being shown, surely.
I would
I mean,
respectfully submit, sir, that deliberate judgment must be capable of being demonstrated
And how do you demonstrate that?
rather than coming out and showing. I am certain, my lord, that if I indicated to you by my conduct that I took a correct decision, it might not be necessary for me to tell you what made me take it.
So how in this case is
How is
that?
it demonstrated?
Was that demonstrated?
By the appointment. Because the court, the learned trial judge found that even though reasons were not given, on the evidence before her, it did not interfere with the appointment, with the validity or the nature of the appointment. That is clear from the record, sir.
But Mr. Gollop, how do we know on what basis these names?
Pardon me, sir?
How do we know on what basis were these names not unacceptable?
Are we
Not
required to
acceptable.
know on what basis they were not acceptable?
But the
And that-
Constitution says that he must do certain things if the names are not unacceptable.
But the Constitution does not say, with the greatest respect, sir, that he must give reasons. It does not say that. And the court actually says that, the Court of Appeal.
So why did the legislature change the section then?
But that's the point, sir, which I've been hearing counsel mooting all day. Whether because the legislation has changed the character slightly, has it said that this must be the case? I respectfully submit, sir, that nowhere in the Constitution, before or after its amendment, is there a statement that there is a duty to reasons.
No, you're going off, Mr. Goddard, you're going off. There was a provision that entitled the president to select a chairman of the commission in his own deliberate judgment.
Yes, sir.
And then there was a big procedure that said, look, this is not ideal. We want to move from unilateralism to a situation where there's greater consensus, there is consensus.
Yes, sir. Or,
An amendment
as
was
close to it
done.
as possible.
Or as close as possible. An amendment was done. And that amendment sets out a process that seeks to achieve this aim towards consensus.
A list of 6 names.
But if we are to accept your submissions now, then all of that amendment and discussion that went into the amendment would be in vain.
I respectfully submit not, sir. I respectfully submit not, sir.
So how is the public to know that the president simply has not done the same thing that he had the power to do before the amendment was passed?
Well, the conduct of what the transaction will show, sir. One, the president, and my friend went through the correspondence, the list of correspondence. The leader of the opposition submitted a list. The president responded by rejecting it. He also submitted what qualities he was looking for on the request of the leader of the opposition, and submitted another list. The president responded by rejecting the list.
And that's where we have a problem. Because no one knows the basis upon which the president came to the view that those 6 names that were suggested did not meet the criteria which he said would be acceptable.
I respectfully submit, sir, that it is not for no one to know. It lies within the president's discretion, which cannot be fettered.
We have that submission, so
So I go on, sir, respectfully. Reasons as viewed by the Court of Appeal. Paragraph 102, sir. This is page 991 of 998 of the record. When the Court of Appeal reviewed the issue of reasons, it made a number of pertinent observations. At page 32 of the record, at line 13, et sequitur.
sorry, which page are you reading from? Our page?
Page 992 of 998, sir.
Okay.
And it refers to page 32 of the record, sir. 32 of 56. A document, sir, that was filed on the 6th of February. GYCV2019 sir. Which is, in effect, sir, a transcript of the civil appeal number 100 of 2018. This matter, sir. Is that in the record? It is page 32, sir, of a document filed in this court. 56 pages. Does the court have it, sir?
So this is the transcript of the Court of Appeal decision.
Yes, sir.
Passage JA.
Yes, sir.
Subsequently, we have had the written, proper written judgment, have we not?
Yes, sir. Unfortunately, again, administrative bungle, we have not got the official written documents. I only got that of Justice of Appeal Persod yesterday by email. We've not seen the other 2. But this transcript has what may be summaries of each person's judgment.
Yeah.
This is the judgment of Justice of Appeal R. Persod which starts at page 29 of 56.
Yes, go ahead.
Yes, sir. At page 32 of the record, this record, Justice Prasad found, 1, the authorities put before the court from the learning gleaned from the cases and other sources and materials confirmed that it has been established that, and I quote, the non-production of reasons or the non-giving of reasons by itself does not vitiate a decision given by a public officer. She, however, went on to express the view that with the development of administrative law, it may become a mandatory requirement sometime in the future, but was at pains to point out that there is no express provision in the Guyana Constitution, and it may be added, or in any statute, that required conformity, to a rule which made it mandatory to provide reasons. Be that as it may, Justice of Appeal Prasad placed reliance on the finding of the learned Chief Justice in the court below that, and I quote, the absence of reasons did not permit any adverse inference to be drawn on this occasion, unquote. The learned Chancellor Cummings Edwards also addressed the issue of reasons and was very emphatic at page 48 of the record. That is the same 48 in this record, where she expresses a view, and I quote, albeit the Constitution does not provide for reasons to be given by the President, as the Chief Justice found. And I find no reason to disagree with her in that regard. So that the assertion by my friends that the Court of Appeal found that there were no reasons is not absolutely correct. What is worthy of note is that the learned Chancellor did find, in disagreement with the Chief Justice and in agreement with counsel for the Attorney General in the court below, that delay and public interest advanced as the reason for applying the proviso could be seen as an instance of giving reasons. So that the issue of reasons continues to haunt the corridors of public law. It is clear that the jurisprudence has been moving on a case-by-case basis to suggest reasons may be a part of good administration, even though that phrase, good administration, continues to be a very unruly horse, because nobody has yet sought to put a statutory definition to it. And I dare say it is not easy, because we are, on one hand, balancing good administration in the sense of administrative workability, to, on the other hand, good administration to reflect fairness and transparency, etc., etc., etc. So that courts have been caught in this dilemma on the issue of reasons. And that is why Chief Justice, as she then was, Barnard, in Rehanneman, agitated that the issue should be put beyond doubt by legislation, as happened in Barbados, and has since happened in Trinidad and Tobago and Jamaica, where statutes are now saying, they're now imposing a duty to state reasons for administrative decisions. And indeed, the specter of the common law still looms large, in that, even though they have come out and said you should give reasons, as in the case of the Barbados Administrative Justice Act, having said reasons are to be given, one, it requires reasons to be asked for. 2, to be asked for in writing. 3, to be asked for in writing within 14 days. And then it throws in a coup de grace, as it were. It excludes every single body that one would reasonably require reasons from in a list or a schedule of bodies that are not required to give reasons. So that is the dilemma that haunts this reasons doctrine. But here, I respectfully urge the court to find, as the learned trial judge did, that the absence of reasons did not adversely affect the decision-making process. In fact, I also urge the court to observe that one trial judge, one justice of appeal said reasons were given. She didn't agree that no reasons were given because she saw in the statement and in the correspondence of the president, the correspondence passing between the president and the leader of the opposition, reasons for his decision. But I respectfully submit that to ask a judge, a court, to give reasons on every occasion, like this Justice Ram Logan says, and which Justice Witt suggested this morning. Let me quote Justice Witt correctly. I took a note. When he asked, would not we, in asking for reasons all the time, be throwing the court in a tangle? So we may come down to the point, respectfully, that where you ask for reasons for everything, you would effectively be fettering the discretion of a judge. Of course, we know there's nothing such as an unfettered discretion. But asking for reasons which would result, or could often result, in administrative unworkability, could be put in an unnecessary fetter.
Okay, so your submission is that the president is not obliged to give any reasons for his determination the list of names
either
or
the common
persons
law
on the name.
or statute or anything, sir.
Okay.
In this particular situation, though, sir, I would urge the court to examine the factual matrix. An appointment had to be made. There was a grave urgency required in making of that appointment because local government elections were coming up. Elections were coming up in 2 years, quite imminent, and there had to be certain parts of the electoral machinery to be put in place. 1 list, 2 lists, 3 lists, and the president found dithering in the administrative process? Respectfully.
Yes, it's a bit
Giving
like,
of reasons to that extent can lead to bad administration. And that is a submission. And I respectfully submit that from the factual matrix, that was the decision which the president found himself. Politics. It's not law we're dealing with, sir. Politics between 2 opposing forces. And that is what causes the difficulty in public law, because it is politics. And the consideration of one side's man or woman being appointed, as opposed to acting equitably and fairly are competing considerations. So how long do you go on? 8 months was the time frame I heard being thrown around. Was it reasonable? Was it in the interest of good administration to allow this situation to continue unchecked? Or on the other hand, was it not reasonable for the president to say, look, enough is enough. I am being guided by delay, urgency, public interest, and this appointment must be made. I will apply the proviso as the Constitution allows me to do.
Okay,
Has been a lot.
we have that submission, Mr. Gara.
Yes, sir.
Yes.
One last point, sir. There has been a lot said about consultation. But consultation in the public machinery is no more really than not doing something behind somebody's back. That is what consultation is. Indeed, who got that in there? This is just a little note, sir, which I would like to read, and I can pass it up for the court as well. From the Halsbury Laws of England, the consultation must be in respect of proposals which may include alternatives, although there is no duty to consult on all possible options or on alternatives that are not viable. The decision maker must consult with an open mind, but he's not bound by the views expressed to him, nor is he normally obliged to enter into any dialogue with those who express them. And a number of cases are cited to support that point. So let us not be sidetracked away from what are the political realities of a situation. A public functionary cannot be held to ransom on the guise that he has not consulted, or he must conduct dialogue to the extent that he must reach consensus. Especially in a particular situation like this. Respectfully, sir, I will conclude by invoking your lordships.
You just said what you just read was cited in several judgments.
Yes, sir.
And you have provided us with all those judgments?
I have sent up one of them, sir.
Okay, great.
I shall pass this up to the court. Pass on one to Douglas.
Yes,
Yeah. Thank you. Yes.
Yes, my lords. So, respectfully, I urge the court to disallow the appeal.
They're all different.
To disallow the appeal.
Yes.
And I should ask the court not to be persuaded by my friends' urging, to find that both parties were wrong, so we should have an order in suspension. That would defeat the practical political purposes which have brought us here.
correct.
Because we have been brought here by political considerations. So that too would create a burdensome and unnecessary administrative bungle if this court were to make that kind of order which my friend has urged it. I'm obliged to the court.
Yes, thank you very much.
Can I ask you one more thing? And going back to your very first statement, where you made a distinction between moral
Morality and law.
and law.
Hart and Fuller, sir.
And your colleague, Mr. Thorne, said, yes, both the president and the leader of the opposition have to act in good faith.
Yes, sir.
My question is good faith a matter of moral or a matter of law?
It is both, sir.
Okay.
I think I can do that. And that is why public law is such an interesting thing, because a few comments were made about legitimate expectation and so on, which is another one of those doctrines that is very, very, very much up in the air. Up to this day, since Breen and those cases, can the courts decide that we should go beyond just a hearing, which is the one limb of legitimate expectation, or whether we should go to the substantive limb, which says you should get the substance of the expectation
So you're not
which
go-
you were heard on.
You're not going to take us down that limb, though. You're not going to take us down that road, please.
No, sir, I was walking away while I said that, sir.
Yes, sir.
I was just responding to Justice Witt in that regard.
Yes.
But I was making the point that that is a typical type of argument that surfaces in public law all the time. That is why statute is important. That is why it is important that we put these things down in a statute. I'm obliged to you, sir.
Yes,
Thank you very much. Yes. Have any response, Mr. Mendes?
Yes, please.
10 minutes?
Yes.
Suppose I go. Trying to move quickly there.
Thank you very much, Your Honors. The authority that my learned friend cited from the Trinidad and Tobago High Court, Caribbean Book Distributors Limited, is a decision of Justice Ramlogan given in 1997, in which he said, while it is desirable to give reasons, if it were the general rule that the administration should give reasons for everything that it does to all those who may be affected by its decision, administration would come to a standstill. The applicant must show that in the circumstances there was a duty to give reasons. That duty would arise if there were special circumstances. The applicant has shown none and no authority has been produced to support the contention. That statement was of course made before the Privy Council handed down its decision in the Stephan case, which has been cited to you, and I'll ask you to look at page 1300. It appears at page 2007 of the record.
What is the page?
Page 2007 of the record. This is Stephan against the General Medical Council. And if you look at towards the bottom of that page, this is what the Privy Council is saying. The trend of the law has been towards an increased recognition of the duty upon decision makers of many kinds to give reasons. This trend is consistent with current developments towards an increased openness in the matters of government and administration, but the trend is proceeding on a case-by-case basis and has not lost sight of the established position of the common law that there is no general duty universally imposed upon all decision makers. It was affirmed in duty that the law does not at present recognize a general duty to give reasons for administrative decisions, but it is well established that there are exceptions where the giving of reasons will be required as a matter of fairness and openness. These may occur through the particular circumstances of a particular case, or as was recognized in ex parte dental surgery, there may be classes of cases where the duty to give reasons may exist in all cases of that class. Those classes may be defined by factors relating to the particular character or quality of the decision, and we would say that that falls squarely, or that applies squarely to the particular decision we are dealing with, as where they appear aberrant, or to factors relating to the particular character or particular jurisdiction of a decision-making body, as where it is concerned with matters of special importance, such as personal liberty. We respectfully submit that this particular decision of the president is one of special importance. It is to appoint the person who is standing as the final decision maker among the other appointees of the commission, 3 of whom are appointed by the president, the other 3 appointed by the opposition parties. So the chairman of the commission, who is leading a very important commission that will determine the lists of electors, determine all other matters pertaining to elections, the parties must have confidence in that commission, and therefore the chairman holds a pivotal role at the head of that commission. And therefore, that particular decision is one of special importance. It may not involve personal liberty, but it involves something quite large. The public must have confidence in the results of an election, and the role that the election commissions play is crucial in that. But then the Privy Council goes on. There is certainly a strong argument for the view that what were once seen as exceptions to the rule may now be becoming examples of the norm, and the cases where reasons are not required may be taking on the appearance of exceptions. So the opposite of what Justice Ramlogan was saying in 1997 is what is being said by the Privy Council in 1999, 2 years later. And of course, in 2017, you see Lord Justice Elias saying in the Oakley case at page 3775, that's one at the top of the page, after just citing
What's the page number for this?
This is page number 2022. And he says, just after quoting from the Stefan case, in view of this, it may be more accurate to say that the common law is moving to the position where there is no universal obligation to give reasons in all circumstances. Whilst there is no universal obligation to give reasons in all circumstances, in general, they should be given unless there is proper justification for not doing so. So quite the opposite of what Justice Ramlogan was saying, which is that you have to show special circumstances to impose an obligation to give reasons. We have come to the stage where generally speaking, you should give reasons unless you can justify not having to do so. My learned friend, I think, is submitting that somehow the administration would collapse if the president in this instance is required to give reasons. But he is only required to make this decision to appoint a chairman every so often. So I can't see that the general administration would somehow collapse if he was required to say why he is rejecting persons on the list. And in fact, it would enhance good administration if he were to do so.
Well, I thought, and I don't want to disturb your sequence, but I thought another reason he was giving was Article 111 of the Constitution.
Yes.
Where he suggests that the president is authorized to act in his own deliberate judgment.
Yes.
So what does that mean? And the question is, that seems to be contrasted with a situation where the president must act on the advice or recommendation of somebody else.
Yes, that is all that means. It means that whenever you see in the Constitution, and this is a feature of a number of constitutions in the region, wherever you see in the Constitution the president being given a power to do something, you are to assume that he does that power, or he exercises that power in his own deliberate judgment, and he does not have to act on somebody else's say-so. What this is saying is that he acts in every case on his own deliberate judgment, except where the Constitution or some other law says that he must act on the advice of somebody else. What this means is that in deciding whether the list is not unacceptable to him, he must make a decision in his own deliberate judgment. Himself. Yeah. He's not to take the advice of somebody else and act on that advice, or take the recommendation and act on the recommendation of somebody else. He is to make up his own mind. It does not mean that he is immune or somehow excused from acting in accordance with law. following proper procedure, taking into account relevant considerations, acting in good faith. He's still required in his deliberate judgment to do so. And as a matter of fact, as His Honor Justice Hayton pointed out, there's an emphasis on a deliberate judgment, which is quite the opposite of saying, well, I can do whatever I want and I don't have to account to anyone. Because that is effectively what my learned friend is saying. If it is that you don't have to speak to the leader of the opposition, to let the leader of the opposition know what might be not unacceptable to you in advance, you don't have to do that. And after you make your decision, you don't have to say why, then this court cannot question him at all. That's basically what he's saying. So we are, in fact, as the President is suggesting, back to the situation prior to the enactment of Article 161(2), where the President could act unilaterally and is otherwise unaccountable. We have gone beyond that. We're in a stage since 1999. The Privy Council is talking about openness and transparency, greater openness and transparency. We are 20 years on from that.
And at the risk of diverting even further from your proposed scheme, could I ask another question about Article 161(2)? Because I put to counsel on the other side the question as to whether this foresees or foreshadows some kind of sequence in the events.
Yes.
There's the issue of eligibility, judge or somebody qualified to be a judge, fit and proper person. There's the issue of not unacceptable.
Yes.
There's the issue of the consultation, because the leader of the opposition submits the list after. So that obviously puts some sort of time component into the equation. So he consults and then he submits the list. So, of course, in drawing up the list, he must have some idea as to what is acceptable or not acceptable to the President.
It seems plain. The leader of the opposition, in constructing his list, must bear in mind questions of eligibility first of all. So he has to make a decision at that initial stage as to the eligibility of the persons he's putting forward. If they are not eligible, then he's wasting everybody's time. So he has to make that decision first and foremost. Secondly, if his list is to contain persons who are not unacceptable to the President, then he must make that decision before he submits the list as well. And how can he determine whether persons are not unacceptable to the President unless he is having a conversation with the President about what is not unacceptable to him? So it logically requires a conversation.
Where does the consultation take place in that sequence?
For the list. Before the
list.
No,
the consultation with the Assembly.
No, well, he is also, that will take place before the list is provided. He must also be canvassing their views to make sure that the list that he puts before the President is a list that they are happy with. But of course, he doesn't have to agree with them. He only has to engage in meaningful consultation. So they may put forward persons that he doesn't agree with, that is the leader of the opposition. As long as he consults with them and takes their views into account, he can then put forward the list that he, the leader of the opposition, considers to be the appropriate list. But in doing so, he must put forward a list not unacceptable to the President. So it must mean that he must make that determination before the list is presented, which must mean that he has to have a conversation with the President before the list is presented. So the implicit in the provision is an obligation on the parties to have a conversation with each other.
Yes, but I was thinking that that is also implicit in how the thing is worded. How it
Absolutely.
Is, how it is worded.
Absolutely. In the wording itself takes you logically in that direction.
Yes.
It cannot work otherwise.
No.
It simply makes no sense otherwise.
Mr. Mendes, Mr. Thorne, your friend, seems to have a bit of a problem if you followed that course that we have spoken about. He seems to suggest that that would mean that the leader of the opposition would control the process. And I heard that more than once, and I wondered whether in your view, there was some element of unfairness that I had not seen. If that is the case, I'm
Sometimes,
trying to follow it.
my lady, you have to forgive counsel on this side. Sometimes we may overstate our case. My learned friend, with all due respect, if the only list that the leader of the opposition can present to the president is one that contains persons who are not unacceptable to the president, then how is the leader of the opposition controlling the process? The leader must ensure that that list is not unacceptable to the president. So he must pay serious regard to what the president thinks.
President's calling the shots, you would say.
The president is calling the shots, in effect, as far as the composition of that list. So how could that be unfair to the president? And how can you characterize that as the leader of the opposition dictating to the president what he ought to do? When he must, logically, he must engage with the president, as both Justice Gregory and Justice Prasad have indicated. The Constitution itself envisages an engagement process before the list is put forward. That is what it clearly envisages. Now, my learned friend has put before you extracts from the Halsbury's laws. Unfortunately, is that the cases that he attached are dated cases which do not really reflect the current approach to consultation, but there is an important passage in Halsbury's which, hoping that maybe I'll ask, I can read it from the screen myself. Right in the middle here, Your Honors, that section. We, of course, are indicating that there must be engagement. If we don't call it consultation, it doesn't matter. There is implicit requirement of engagement. But what Halsbury's is saying is whether or not a consultation is required by law, if embarked upon, it must be carried out properly. To be proper, a consultation must be undertaken at a time when proposals are still at a formative stage, because this doesn't apply exactly to the process that we are speaking about. It must include sufficient reasons for particular proposals to allow those consulted to give intelligent consideration and an intelligent response. Adequate time must be given for this purpose, and the product of consultation must be conscientiously taken into account by the decision maker. The important part of that is that if you are going to engage at all with the leader of the opposition, then you have to give reasons for the choices that you're making, for the direction in which you're suggesting that the leader of the opposition is to go. So if you decide that the list that is provided is unacceptable, then you have to say why. You've got to say why, so that there can be then a proper response thereafter, or at the very least, that the parties would know on what basis they can go to court to challenge the decision, which on the face of it is aberrant. Now, the point that is also made in the Privy Council decision in Stephan, but is also and as well in the Oakley case, and I'll attempt to be very quick. You will see at page 3772. Which is at page 2019. This is, Lord Justice Elias was just referring to the situation where reasons are required where there is an apparent aberrant decision. He says, an example of an aberrant decision of the type referred to by Sedley J. in Ex parte Dental Surgery is the Court of Appeal decision in Ex parte Cunningham. The case concerned the amount of compensation which the Civil Appeal Board awarded to a prison officer whom it found to have been unfairly dismissed. The officer had no right of recourse to an industrial tribunal. In accordance with the board's policy, no reasons were given for the amount awarded. The court held that the amount was so low when compared with the amount which an industrial tribunal would have been expected to award, that it was prima facie irrational. Lord Donaldson held that this was a judicial decision where fairness required the giving of reasons. So that is an example of a case where the court is saying that the decision appears to be so aberrant that there's a duty to give reasons for it. The leader of the opposition respectfully submitting that where you provide on the face of it a list of persons who are eligible either because they're judges or fit and proper, and therefore the rejection of that list, particularly the second one, where on the face of it the list complies with the criteria that the president has set out, that decision appears on its face to be an aberrant decision, and there must be an explanation for it. A duty to give reasons arises certainly in those circumstances, if not generally speaking. It arises in the circumstances of this case. And at the very least, it arose at the stage where the case became before the court, and the court was reviewing the rationality of the decision on the part of the president. He at least at that stage owed a duty to the court to explain himself. Why have you rejected 18 persons who on the face of it are fit and proper, or judges, as the case may be? We have no answer to that question. But yet still my learned friend says, forget about it. We walk away and we expect that the public would have confidence in a decision of that nature. Respectfully, Your Honors, those are not submissions that ought to be accepted.
Mr. Gollop is saying, well, yeah, this is all ideal, what you are talking about. This is Guyana, not Arcadia, so to speak, where everything is done in reason and tranquility and so forth. How do we deal with that? Especially if the court would have to interpret this provision with reading in certain requirements, how far does a court go in that, you see? There are many ways that lead to Rome, as they say. There is probably not one concept or one pattern how to get there, and Rome being then the ideal of proper consensus, reaching consensus. So how do you expect the court to deal with that issue?
We are dealing with Guyana, and we are dealing with a country that has an admirable constitution that goes to great lengths to declare fundamental rights and freedoms, which this court has held in very recent cases to extend or to have far-reaching consequences as far as equality is concerned at the very least. You look at every aspect of this constitution from the very first declaration in Article 1 that it is a democratic society, and it is based upon these principles, and from that one can only conclude that the intention is that all public authorities must accord with basic principles of openness and transparency. So we are in Guyana. I don't know about Arcadia, what their constitution is, but we are dealing with a modern constitution that imbues openness and transparency. And what my learned friends have been submitting to you, with all due respect, is trying to take Guyana into the past, into a situation where you have a monarchy, a president who is exercising powers that are unreviewable. That is not this constitution. This constitution goes to great pains to ensure that the rule of law is respected and that democratic principles are followed. And this court will, it is not asking this court to do very much to say that the parties must have a conversation before a decision is made. That is basically what, you're not asking them to do anything that is strenuous in any way. It is something that public authorities are expected to do in every country, whatever their constitutions may provide.
Okay. Thank you.
I mean, might there be problems over whether a declaration is made or whether orders are made? Or whether we can get undertakings?
Well,
if your views prevail.
Well, as we've indicated before, we'd ask for the opportunity to address you more fully when the result of the second set of proceedings are known. But of course, the options are declarations and the quashing of the decisions, and of course, directions that the decision be taken again in accordance with the guidance given by the court.
Just out of curiosity, do we know whether all counsel here today will be with us tomorrow?
We will be.
You will be.
But my learned friends, Mr. Thorne and Mr. Gollop, won't be.
Honorable Attorney General will be here tomorrow?
The Attorney General will be here.
Yeah.
I gather he'll be making submissions tomorrow, I'm told. Is that right? That is what I was told by
Thank
counsel.
you, thank you,
But
thank
we'll
you.
see.
Thank you very much, Mr. Mendez.
Much obliged to you.
Thank you, Counsel. We will naturally take time for our decision, and we will let you know when we are ready with it.
Court rise.
I'll make you no presentation.